mention.
May I please, your lordship, regarding item 42, lordship, may I please come after, sir? Next week, lordship.
Diaries.
42, my lord, case diary not received.
It is DRI case, lordship, I have already informed.
Not diary, not 42. Issue first requisition for the diary. Poster. Interim is there. No?
Lordship, interim is there.
Interim bill granted by order dated extended till the next date of listing. Okay, list on which date?
Google map.
Next week, lordship.
After next week, lordship, if possible.
After next week or next
Lord.
week?
November,
27.
much obliged, your lordship, much obliged.
May I please, your lordship.
Yes.
Lordship, prayer for listing a BA lordship, and yesterday lordship, item number 3 and 26 already been disposed of out of same affair, same forwarding report lordship. As on today lordship, and 86 days in custody lordship. Can it be lordship at today?
Is it a new matter? or-
New lordship,
New-
earlier rejected lordship
Yeah.
by lordship.
May I please, my lords? My lords, item number 66 in the supplementary list. That's the last item on the board. Perhaps my lords remembers on the 13th, the case was listed
Yes, yes.
and Mr. Mahajan Lalit Senior had mentioned the matter
Mhm.
saying that he needs some time to file the affidavit.
Okay.
It has come on record, my lord.
It has,
However, my lord.
It has been
today,
filed?
My lords, yes, it is filed. My lords is aware today there is a reference also.
Mhm.
Perhaps it will not reach. Now, may I plead, my lord, considering the urgency of the matter, it will be upgraded, my lord. I am reasonable, my lord. Perhaps after the motion matters are over, it can be taken up before the admissions, my lord. Because
let's
we,
keep it open. If possible, we'll try.
before the admissions, my lord, I pray, my lord, because it has
Oh,
been
yeah.
long pending. I'm
Order,
sure-
order matter, no?
Yes, my lord. Otherwise it will not reach.
Let it be before 1 o'clock, my lord, because my senior also has to reach me.
Hmm.
Is it-
1 o'clock or or at 2?
Motion is not.
Or at 2. Keep it open, we'll keep it.
May I please, your lordship? Lordship, I beg to mention item number 14, my lord. It may be come up after 1 week, my lord. My senior is out of station today, my lord.
Item 14,
14.
list after a week.
Interim may be continue, my lord.
Yeah, the interim order granted by the order dated. So shall continue till the next date of listing.
Most obliged.
May it please, your lordship, with the concern of the other side, I beg to mention item number 16, my lord. I for response number 2. Now here, my lord, what happened, the matter was referred to the mediation, my lord.
Mhm.
And the mediation process is successful, my lord. And the final agreement will be done on 23rd.
Very good.
So, my lord, if it can be fixed on 4th, my lord, we can dispose,
No problem.
4th of November.
Mr. Land Council. Mr.
M. Smith, my lord.
M. Smith.
Correspondent.
For respondent two submits that efforted mediation has been successful and prays for fixing the matter on 4th of November. List the matter on 4/11/2000.
This interim order, my lord,
The interim order granted earlier by the order dated so and so shall continue till the next date of listing.
obliged.
May I please, lordship? My lord, we are praying for listing, my lord, admission matter, my lord. It's a my lord, criminal revision, my lord. Can it be on, my lord, 24?
Senior bench you have to reach, senior bench. Senior, you have to mention
My
the
lord,
first.
special, my lordship, it's a special act, NI Act matter, my lord.
It will lie before this court. That's.
Yes, my lord, it's special, act, as per my lord, roster, lordship.
But take it next week. No, but today it will be, I don't know.
But we are praying, yes, well, next week, 24/10, my lord. Obliged, my lord.
My lord, with regard to item number 13, my lord. 13. My lord, today, some adjournment, I'm seeking some adjournment today, my lord.
We pay for the petitioner, my lord. There is an interim order that we extend.
Item 13, adjourn for the day. Interim order granted by, I'll continue. List on, suggest a date.
After 1 week,
29
29th of October.
October.
Deeply obliged.
May I please, your lordship? Your lordship, I beg to mention item number 54 for adjournment, as my senior is out of station.
54.
Yes, your lordship. I'm for the petitioner.
Petition criminal 54, adjourn for the day. When do you, any date you want, suggest?
Any date next week, your lordship?
Next week or day after? Will it be late? It will be on 30.
Much obliged, your lordship.
May I please, your lordship. Lordship, I beg to mention item number 48, lordship. I'm seeking an adjournment, Lordship, in this matter, Lordship. And Lordship, matter may be listed on 2910 along with BA number 3088 of 25.
Diary
Same
receipt?
FIR.
CD received, my lord.
Another case is pending, Lordship, on
But
2910.
CD will be held back.
It's only 20, this 29, my lord.
If you can, if there's no inconvenience, it can. Item 48, adjourn for the day. So interim order is there.
Yes, my lord.
Interim order stands extended till the next date of listing.
On
List
29,
the matter on 29/10/2025 along with BA number
3088 of 25.
3088 of 25. Case diary be retained.
Highly applied.
No problem.
Yes.
Because
Highly
otherwise
applied.
case diary should not be 12 days.
Now, board beda 29, I may be allowed to send back, I will again take.
You want to send back?
29 is,
Oh, the diary may be sent back and procured again before the next date, huh? Retained on charge.
Highly applied.
May I please the lordship, my lord, out of same FIR, one case is fixed on 31st October 2025, my lord. CD was called for. Kindly take this week.
Along with that,
Yes, madam. BA number 3266.
it is submitted by learned counsel. That connected bail application being BA number
BA number 3266.
3266 of 25 arising out of the same FIR is fixed for bail
CD.
hearing on 31/10/2025 and praise for tagging this matter with the same. Prayer is allowed. List the matter. Call for the case diary.
Yes, my lord,
Not
yes.
the-
Call for case date.
Call for the case diary. Oh. Case number দিব লাগিব।
Case number 2, my lord.
NDPS case number 1 of CLCL it was, huh? Page 2. Page 2. It is at the stage of investigation.
Yes, Lordship.
Okay. Third, and they call learned standing council NCV. NC customs,
Custom.
Customs,
on-
customs.
customs. So list the matter on 31/10/2025 along with BAS.
Obliged.
Highly obliged.
May I please your lordship? Lordship, here lordship, the petitioner was arrested on 24/7/2025. As on date, lordship, 86 days, lordship. Lordship was, earlier lordship, this bail petition was rejected. That reject order is at page number 39, my lord. Admitted position is that lordship, the stolen property we purchased by the petitioner. Petitioner is a jewelry shop owner. Page number 40 would be relevant, lordship.
Acha, acha.
Paragraph number 3 and 4. Page number 40.
Yes. Should we get the updated CD?
Yes, my lord.
86 days. because
86 days.
Then you
lordship.
fix it on the 91st day.
Yes,
There is 86
yes,
on reopening
yes.
immediately on. If it's not come, then he'll get statutory. Right? Ahmed, additional people. Call for the updated case diary of Bajari Chera, PS case number. Bajari Chera, PS case number 77 of 25. The accused is stated to have been arrested on 24/7/2025. And earlier bail petition was rejected on 19/9/2025, a copy of which has been annexed. This is the matter on 22/10, 22/10/2025. Bail hearing.
Highly applied.
May I please, Your Lordship? In this case, Your Lordship, petitioner was arrested on 19th of this September, Your Lordship. This page, FIR is on page number 11. Annexure. There is allegation that this petitioner has created some fake account in the name of the complainant and Instagram and uploaded some options photographs in Instagram and Facebook, Your Lordship. Subsequently, after initially he was not named in the FIR, Your Lordship. Subsequently,
Herein the petitioner, he is in custody for 76 days, Your Lordship. And this is the, herein the petitioner, he is in custody for 76 days, Your Lordship. And this is the second bail application. Earlier it was rejected, Your Lordship. Page 12 is the FIR, Your Lordship. Herein, the other co-accused has already been released on bail.
Yes.
Boroma, please.
Investigation is completed.
Yes.
Diary is there.
No, man. Already intimation regarding.
Or it
I think-
will go.
I think yesterday also, Your Lordship,
Yeah.
we-
I think so. I think so. It will, 20 page 25 or probably. First and second paragraph below. Sorry, no, you, page 22 below. Page 25 now, 22, with the order. First and second paragraph. Come to left. M.A.M. Khan. First, second, and third paragraph below. Second and third paragraph. It is submitted by the learned additional PP that in the meantime, upon completion of investigation, charge sheet has been submitted in the case. In this context, the learned petitioner counsel, Mr. Khan, submits that some co-accused have already been granted bail by this court yesterday on the said ground of completion of investigation. In the aforesaid facts and circumstances, the bail petition is allowed and the accused person so and so is hereby allowed to go on bail of rupees dot. You just give the same terms and conditions. Same terms and conditions. Probably around 30,000 or something have given, no? Will be. The bail petition stands allowed and disposed of on the aforesaid terms.
Item number 59 also same number.
Then number 59.
59. Here also the petitioners is behind the bar since 2/8/2025, my lord. That is on 77 days. as of
2/8/2025. Item number 59, also same order, might affect.
Deeply.
May I please, Lordship? Lordship, 483 bail application. Lordship, petitioner behind the bar last 57 days, Lordship. May Lord-
28/8, right?
57 days,
28/8.
22/8,
He was arrested on 22/8.
22/8. Mandatory period is, Lordship, 60 days. Lordship, may kindly turn up page 11 FIR.
60 days completed?
No, no.
Anyway, that's not, page 11.
11, may I read? সন্মানপূৰ্বক নৃত্য নিবেদন এই যে যোৱা ইংৰাজী ছেপ্টেম্বৰ 2021
Hmm.
ওপৰত উল্লেখ কৰা পদকীয়া গ্ৰহণে মোৰ ঘৰত আহি চৰকাৰী আঁচনিৰ টকা বেংক একাউণ্টত সোমাই দিম বুলি মোৰ পৰা আধাৰ কাৰ্ড পেন কাৰ্ড লৈ যায়। পদকীয়াগণে প্ৰবঞ্চনাৰে বিভিন্ন প্ৰলোভনেৰে প্ৰলোভিত কৰি বিশ্বাসঘাতকতাৰে উক্ত নথিসমূহ লৈ গৈ অনলাইন মাধ্যম যোগে মোৰ নামত ঋণ লয় আৰু মোবাইলৰ OTP সংগ্ৰহ কৰে। মোৰ নামত প্ৰায় 4,000 টকা লোন লৈ যদিও বৰ্তমান পৰিশোধ কৰিবলগীয়া টকা 9,000। মোৰ অজ্ঞাতে পদকীয়া গণে প্ৰবঞ্চনাৰে উক্ত ঋণ কাৰ্য সংঘটিত কৰে। উক্ত কথা মই যোৱা কেইদিনমান আগত অৱগত হওঁ। পদকীয়াগণে আমাৰ গাঁৱৰ প্ৰায় 20 জনৰ অধিক নিৰক্ষৰ লোকৰ আধাৰ কাৰ্ড, পেন কাৰ্ড সংগ্ৰহ কৰি প্ৰায় 2,50,000 টকা নিজাববীয়াকৈ আত্মসাৎ কৰে। Lordship, may kindly turn page 15, Lordship. Column 4, account summary. Here is the petitioner's, here is the informant's bank account summary. And here is showing current balance account is 0. Already the accused person, before his arrest, already he paid the loan amount. And subsequently, the petitioner lodged this instant case 1/8/7/2025. And here is the 15/6/2025, the accounts already closed the account. So I have no knowledge regarding that. I am belong from Morigao, and the informant belong from Kamrup Metro. Moreover, I am the accused number 2. Accused number 1 is already released on bail by this Lordship Court.
Okay. When the diary is available,
No, my lord, diary is not available.
when back.
Suppose, my lord, in this case now petitioner has, my lord, annexed this document. Probably in case of one, my lord, victimized person, he has paid and, my lord, that account has been closed. But regarding all
Get
the
the
accused
diary.
persons, so after committing the offense, if he, my lord, by this way, he can close one of the account of the one of the victim, that cannot
Heard.
be.
Lordship, just 3 days to go for mandatory period. And the court is off, Lordship.
All for the case diary of Petri PS case number 61 of 25 under section 3.
Sir, today's CD not available, my lord.
Huh?
Today
It is-
case diary.
No, I'm saying that call for the case
Oh,
diary.
yes, yes.
Is call for the updated case diary of
Yeah.
Khetri PS case number 61 of 2025. Because this is a subsequent petition, right?
Subsequent petition.
An earlier bill petition was rejected on 26/9/25, a copy of which has been annexed. On the reopening day, can you get it?
Yes, yes.
So he's completed 76, sorry.
Lordship, on
50.
Monday, mandatory period.
Monday, Tuesday is holidays,
Holiday.
When
Yes, Lordship, make only any condition, Lordship, I may allow to go on bail, Lordship.
22. How many days he has completed?
22.
On Monday, it will be completed.
Wednesday, 22/1. 22/10.
Oblige.
May it please your lordship. Lordship, for 83 bail application, my lord. Page 8 is the FIR, my lord. This is a long FIR, my lord. But kindly peruse page 18, my lord. That is forwarding report. And there is a brief of the FIR, my lord. Petitioner is behind the bar since 21/8/2025. That is on 58 days as on today, my lord. And the 60 days offense, my lord. The basic allegation is that the one foreign national from UK, my lord, demanded some money from the complainant through Facebook, my lord.
Oh, yeah.
And on the alleged date of occurrence on 5/11/2014, it's a 14 case, my lord, 2014 case, my lord. She deposited rupees 25,000 in the account of the present petitioner, my lord. And our contention is that, my lord, the present petitioner is a street food vendor, my lord. Some of his customer requested him to provide his account number that they can withdraw some money, my lord.
From his account.
Yes, my lord.
I think he was arrested on 21/8.
21/8 and as on today, 58 days, my lord. It will, 60 days will be completed on Sunday, my lord. And the court is open on 22nd, my lord.
But we need to see the FIR.
Yes, ma'am.
Case diary.
Open
Without
to
case
see.
diary, it'll be, you can move before the
My lord,
duty
after
magistrate.
some time, I'll- if
You
possible.
can seek statutory bail, otherwise fix it on 22nd.
Yes.
This kind of cases, how is he connected? He is not that person.
Yes, my lord.
Anyway,
This is
any-
Another person, my lord, from
Here.
other nation.
Case diary of CID PS case number 18 of 25, no, short पे लिखा था. The accused was arrested on 21/8/2025. This is the matter on 22/10. That option is there. If you want, you can move before duty magistrate also. But because of this is pending, then statutory bail can be given. That's not a problem.
After petitioner is behind the bar 50 days, my lord, arrested on, my lord, 28/8/25, my lord. My lord, affair is placed, my lord, 14, my lord, long affair, my lord. Kindly see, my lord, petition paragraph number 3. May I read, my lord? The informant, namely Krishnanu Deka, who is the one of the employees of Bajaj Finance Limited, loss and Rajar, before the Godfrey P.S. Krishnamur, interly alleging that one Amit Kumar Sharma is the main accused, my lord, to whom a loan was given to purchase a vehicle Mahindra Thar, so and so, bearing registration number, by way of executing an agreement for loan of so and so, so and so. The said Amit Kumar Sharma not only failed to make payment of the monthly EMI, but also only sold the vehicle, which is still under valuation, by way of creating false document, and also got the registration of the vehicle transferred from the Transport Department, Kamrup to Transport Department, Arunachal Pradesh. This is the fact, my lord. My lord, kindly affair is page 14, my lord. Entire affair, my name is not mentioned in the affair, my lord.
Forwarding report, let us see why he was arrested.
Forwarding report page 18, my lord.
Otherwise, we will get
18, my
the,
lord.
shall we get the case diary? And see?
Yes, my lord, a very
23rd.
serious offense, my lord, where those vehicles are theft vehicles here, my lord, by, my lord, bringing those vehicles, by changing all those, my lord, thereafter.
Today's 50
vehicles-
days, my lord.
Those vehicles were theft from Himachal Pradesh, my lord, thereafter, my lord, here.
No, loan is taken by the Amit Kumar Sharma, my lord.
Borsuk PS case number 91 of 25 diary. The accused was arrested on 28/8/2025. So when do you propose?
On,
Because,
my lord,
aspect of this is also there, 50.
yes,
Next
on,
week you fix it.
on 24/10.
24th?
24.
24th. Number 36.
May I please, Your Lordship?
You want notice?
Supplementary 58 and 36.
36 for bail hearing, no?
Yes, sir, kindly taken up along with 36.
36, that's what I was thinking. You take it up after with 36. See. This, any connected matter is fixed with regard to this, any, in the future, coming days?
Item number 60, my lord.
Umrangsu PS,
It will connected matter.
17 of 25.
Umrangsu, my lord. Today, my lord, there is no connected matter, Umrangsu PS. no.
So diary will be necessary, let's call for the
Diary,
diary.
my lord, that is regarding one Dipu to PS, Dipu, no,
Should I call for the case diary?
Yes, call for this case diary, Your Lordship.
Case diary will be necessary. Call for your good name, please.
R.H. Chaudhary.
Alright, sure. Call for case diary of Umrangsu PS case number 17 of 25. The accused petitioner is stated to have been arrested on 16/8/2025. In this case, this is the matter on, or,
Your Lordship, the matter may be listed on 30th of this month.
okay. You want it on 30th?
Yes.
Education. 30. Any other matter listed? No, no.
No, Your Lordship.
30/10 for bail hearing.
Obliged.
Here, what has happened out of a matrimonial dispute? My wife all of a sudden left me with. And out of the same FIR, well, two persons are already granted interim protection. So well, we are praying that similar order may be passed here also.
Is it?
Copy of the.
For, I think 2 and 3, I think it was passed, right?
Four
Right.
persons are there, all are FIR named.
All are refined. I think 2 and 3, it was filed. So bail
Yes.
was granted, no? Interim bail was.
My
granted.
lord.
You have
And-
the order?
They are minor, but they are the habitual offenders. So far, my instruction is concerned, well.
But still, some conduct is little bad,
Lordship.
urinating on their face.
Statements may be recorded.
Thank you.
But these two persons are not FIR named accused.
These three are not,
No?
FIR name, all are FIR. No,
no, these petitioners are not FIR name.
Not FIR.
not FIR name, well,
Ghulam Mustafa Foidul Islam.
Mustafa is mentioned here. Mustafa
Maybe it may
and,
not be also, Faridul Islam.
yes, well,
He's also named.
yes, well,
Anyway, whatever it is. These two were also named.
yes,
List on 12-11 it is fixed.
My
Same
lord. similar.
একেটা উঠাই দিলেও মই কিবা
Yeah,
কিবি কৰিম।
yeah.
আমি উঠাই list the matter on 12-11-2025 along with AB number 2440 of 2025.
Obliged, ma'am.
May I please, your lordship? Yeah, lordship, what about on Polton Bazaar lordship, police charged me lordship, but they no FIR has been found till date, lord. And the main fact is that on 1/10/2025, some quarrel was there in a puja mandap. The other opposite side was influence of alcohol. I was with my sister. The only thing is that report will be called for, and till then some protection I'll appear and I'll find out what is there in the lordship, if any FIR has been lost.
482 bail affidavit, according to Nisma. 482, invoke 482, the apprehension of arrest, but he does not have details of any case lost before him, lost against him in the Polton Bazaar PS. The call for a report, according to Nisma, Polton Bazaar PS. However, till the returnable date, stop. No coercive measure may be taken against the petitioner. With regard to, no coercive measure with regard to the, any case filed at Polton Bazaar Police Station, right? List the matter on
On my lord, 2710,
27/10,
2810.
28/10.
Much obliged, much obliged.
Lordship, the petitioner's earlier bail was rejected at the initial stage of investigation, Lordship. That order, Lordship, I'd like to show, that is page 15, Lordship, the rejection order.
Page 15.
Yes, Lordship. And Lordship, in this case, the FIR name accused number 4 and 5 already granted bail by the learned trial court. And one of the co-accused, that is FIR named accused number 8, Lordship. 8, who approached before this honorable court, Lordship, and this honorable court was pleased to grant him the interim protection, Lordship, that is space order 22, Lordship. And the matter was,
It's fixed on 30/10.
yes. So, Lordship, my humble submission, Lordship, let the case be be fixed along with that case, and in the meantime, he may be
The
other-
earlier bail petition was rejected.
Yes,
What
it was
ground?
rejected, my regarding
Yes,
granting of
Lordship.
bail to one accused, my lord. Probably may not be, my lord, from the case diary at that point. of time
Lordship,
against.
the person who had granted pre-arrest bail, he is serial number below to me, Lordship.
Just a
And,
minute, I'll let-
Lordship, yes,
Let me read it.
yes.
This was on a specific submission,
Yes, yes, he was present.
which
and
was
he-
accepted at that point.
For the
But this
Lordship,
is a
yes, yes,
previously
Lordship.
rejected application.
Yes,
Let us
Lordship,
see the case diary.
Lordship, kindly let me submit one thing, Lordship.
Yes.
Lordship, kindly come to page number 19, Lordship. This is the observation made by the learned trial court, Lordship. I'd like to point it out, page number 20, Lordship. From the bottom paragraph. On going through the CD, it appears that there is no progress of the investigation since 4/9/2025. Page number 20, Lordship, from
No,
bottom.
I've read.
Yes. It appears that there is no progress of the investigation since 4/9/2025. The injury report of the victim Baharul Islam reveals that he had pain in the abdomen, tenderness and swelling in multiple sides of body, including head. Lordship, there is no such specific injury, Lordship, so far alleged in the affair. On last date, the IO was asked to submit USG, WA and CXR PAV of Baharul Islam today, but no such report is submitted along with the CD by the IO. Further, there is no note or entry in the CD as to whether Baharul Islam undergone any such test or diagnosis, or why no report could be submitted by the IO. No separate report is also submitted along with the CD. Further, there is no material in the statement of one eyewitness recorded under section 183 of the BNSS to show that the accused person have tried to murder the informant victim or the injured or injury sustained by the victim was grievous, Lordship. So apparently, Lordship, the contents of the affair, Lordship, does not make out a case. Earlier, Lordship, section 353, Lordship, and now, Lordship, is 121(2), Lordship. So my humble submission, Lordship, the Lordship may grant some protection, Lordship, in this case, Lordship.
That order was passed by the Land Trial Court on 10/9/25. Thereafter, my lord, your lordship has rejected the present petitioner's bail application on
Anyway.
19/9.
The call for the updated case diary of South Salmara PS case number 103 of 2025. Stop. Then earlier bail petition was rejected by this court on 19/9/2025. It is pointed out that peruse the order dated 8/10/2025. Passed by this court, granting interim bail to another co-accused for the grounds, for the reasons stated therein. The matter is fixed on 30/10/2025. Full stop. This order of the trial court was it before this court at the time of rejection?
No, my lord, after, before rejection of.
Yeah, but was it before this court? I don't know, I don't remember. Was it before this court?
Yes, yes, my lord.
I
No.
don't remember.
Yes.
Yes, Lordship.
Anyway, there might have been some progress. Let us see the case diary.
Lordship,
Please
because
come.
there is a Lordship specific observation, Lordship, there is no injury sustained by the victim, Lordship. So
Anyway.
Lordship, the contents of affair, Lordship, may not be true, Lordship. Because otherwise, Lordship, already,
Anyway, learned counsel has drawn my attention to an order dated, what was the page number?
yes, Lordship, page 19, Lordship.
Order dated 10/9/2025, passed by the learned session judge of the jurisdictional district, in which there is an observation that at that time there was no progress of investigation since 4/9/2025, semicolon, that comma, the injury report of victim Baharul Islam reveals some pain in abdomen and tenderness. But no report has been submitted, semicolon, that comma, in the statement of one witness recorded under 183 BNSS. It is revealed that there is no material to indicate that the accused persons tried to kill the victim or that the injury sustained by the victim was grievous. On the basis of these observations by the learned court below, the learned counsel submits that, like the other co-accused, he also may be protected till the returnable date, even though this is a subsequent bail petition. The prayer is allowed. It is directed that Shri Boya Prabhu. Page 23. 9 to 10. This is the matter on 30/10/2025, along with
Yes, Lordship.
AB number
AB number 2419.
2419 of 20.
I'm over, sir.
May please, your lordship. Lordship, petitioner referring your lordship is the owner of the vehicle. Lordship will find the FIR at page 12, it starts. The relevant at page 16 onwards, lordship. In the FIR, lordship, it is a long FIR, lordship. In the FIR, the present petitioner referring lordship has not been alleged anywhere. And at page 19, shall I read the FIR, lordship? Yes, at page 19, lordship, down below, the lordship will find the name of the accused persons wherein the petitioner of your lordship's name was not endorsed. The FIR is of lordship 36/2025. Subsequently, lordship,
Some drugs were found from these people.
yes,
from these
lordship,
people.
kindly produce page 21, annexure C for a moment, lordship. The petitioner of your lordship is the owner of the vehicle and he have given the vehicle on a rent to one Narula Infrastructure Private Limited, and that was given on 1/6/2025. Have lordship got in the right side of the page and down the signature. And lordship, the petitioner of your lordship is nowhere connected, and only the notice under section 67A was issued to him. Lordship will find at page D, page 22, annexure D. It was issued on only on 26/8/2025. Actually, lordship, on that day, my Zima petition was rejected by the learned trial court. So after that, lordship, the concerned police station has issued this notice.
In the FIR, there is no allegation of any allegation against your
No,
client.
no.
In that case, you can be asked to record. Let me see.
Yes, lordship.
NDPS commercial quantity.
It's commercial quantity.
Commercial quantity.
Oh,
Lordship, at this stage, lordship, since my
57 will be there, no?
Yes.
But,
lordship,
then we have to, then you read the FIR.
yes,
Let
lordship.
us read the FIR.
Yes, sir. Page 16,
Right,
lordship.
my lord.
With reference to the subject cited above, I have the honor to inform you that on 36/2025 at about 2:35 PM, an information was received by OC Nilambazar PS through the Honorable Senior Superintendent of Police Sribhumi, Sri Partha Pratim Das, IPS, that one white color Bolero vehicle bearing registration number so and so, which is suspected to carry a huge quantity of narcotics contrabands, is coming from Sribhumi side to Nilambazar via NH08. Accordingly, a GD entry was made by the OC Nilambazar PS, white Nilambazar GD number so and so dated 36/2025, and entrusted me to take necessary action as per law. Accordingly, Narayan Boro APS Deputy SP so and so authorized me for conducting search, seizure and arrest if any illegal narcotic contrabands found by issuing authority letter under section so and so NDPS through WhatsApp white Nilambazar so and so. Thereafter at 2:48 PM, self along with the OC Nilambazar so and so and other detailed PS staffs, namely so and so, have left the PS. It is to be noted that I also carrying seizure materials like weighing machine, weighing machine, lal candle, covered envelope, narcotics kit, etc., which are available at PS. At 2:50 PM, we reached near the new station road, Nilambazar. After arrival at station road, we conducted a Naka checking on highway 08. At about 3 PM, the said vehicle was coming from Sribhumi side towards Nilambazar via NH so and so. Accordingly, we detained the suspected Bolero vehicle and condoned the vehicle from outside. It is to be noted that inside the vehicle, one driver and two occupants were present. After sometimes, Honorable Senior Superintendent of Police Sribhumi sir, along with so and so, and his staff arrived at the spot. After that, OC Nilambazar called two numbers of independent witnesses who were loitering at the spot, and then
I have explained and asked them to witness to sir's procedure of detained persons. Accordingly, they accepted to witness the same. Two independent witnesses are as follows. Zoidi Bhattacharya and Sanjoy Roy. Thereafter, on suit interrogation of the detained persons identified themselves as Sanur Alam, then number 2, driver of the retained vehicle, Iftiar Rahman Laskar, and and number 3, Sabir Ahmad. Right, Lossi got it. The second line.
Yes.
Yes. And I'm next straight with the third line, and admitted that they were carrying narcotic combinations with them, which is kept inside the vehicle, and the bags and jacket, which is kept inside the detained vehicle and transporting from Mizoram to Nilam Bazar. And the suspected narcotic contraband is supposed to deliver in the name of Abdullah Chaudhary, alias so-and-so, who was waiting at Paharkandi area to receive the contrabands. Thereafter, I served notice under section 50 NDPS to the detained persons for conducting their body search in presence of gazette officer and independent witnesses. It is to be noted that body of the apprehended persons and detained vehicle, I conducted my self body search by the independent witnesses. Thereafter, on being led and shown by the apprehended persons, we successfully recovered 2 numbers of big brown colored pocket web with a adhesive tab from the black color tab within bracket. Bag is kept in the rear seat of the detained vehicle. Inside its black color pockets, 10 numbers of soft cases were found. Further, 2 numbers of soft cases were kept concealed inside a inner pocket of a black color jacket. Again, 54 numbers of multicolor soft case were found inside the vehicle. Out of 51 numbers of 15 numbers of soft cases were kept concealed inside the front right side door of the vehicle. 15 numbers were kept inside the inside the front left side door of the vehicle. 12 numbers were kept concealed inside the middle left side door of the vehicle. 12 numbers were kept in the concealed inside middle left side of the vehicle. During search of the following contraband, the drugs suspected to be heroin and other items were recovered and seized from the joint conscious position of the apparent person. Number 1 Bolero vehicle number so and so. I am the owner of the vehicle, Your Honor, Lordship. 1 bed color school bag.
It was heroin.
Yes,
Heroin.
Lordship.
Suspected heroin.
I was just, yes, suspected heroin.
And Lordship, now all the seized items, Lordship, shall I read it, Lordship?
No.
Your
And-
Lordship, I
and
would just like to
Lordship,
point out
okay,
one
okay,
thing.
Just a minute.
Kindly come to page 19, Lordship. It is to be that by using the narcotic kit which is carried by me, test the suspected heroin and found positive result. The packets of suspected to be heroin were weighed by using the weighting machine at so and so gross so and so, 870.07 gram. After completion of the seizure process, all the seized 70 numbers of multi-color soft cases, a school bag, the black color jacket, were kept inside a brown color cartoon box, which I and sealed by La using the 5 rupee coin. All items were kept inside the brown cartoon box, which I wrapped with adhesive tape and La mark. Signature of independent witness, apprehended person, self were put over the cartoon and box seizure list. Photography and videography were done using by my mobile phone. After commission of seizure, I along with the staff apprehended person, which is article at 6 p.m. I have the PS hand over the seized items, Sirastada and Nilamada, so and so. Therefore, I request to register case so and so. And these are the names of the accused person lost. So, Lordship, I am nowhere connected with the case. So, since the vehicle was rented to one Nerola in Infrastructure Private Limited, Lordship, so at this stage, CD may be called for, Lordship, and I may be protected so that I can appear before the IO and I can submit all the necessary documents regarding the agreement and all. And the only difficulty is, Lordship, I am a person who is earning my livelihood by renting this vehicle, Lordship.
My lord, vehicle is rented to, my lord, I would like to point out page 21, annexure 4, my lord. Vehicle is rented to be a Narula Infrastructure Private Limited, but the control of the vehicle is still with the petitioner, my lord. Your lordship may kindly come to the terms and conditions, my lord. Vehicle must be commercial registration and below 5 years of age. This is the agreement with the own. Vehicle and driver should be available at site location for 24/7 basis. So vehicle is still under control of the present petitioner. So it is the petitioner, after this accepting this offer letter, petitioner has to produce that vehicle for the service of the company.
But there's no, I think he should be allowed to record his statement because because there's no allegation that he was driving or he was present. Because suppose the possibility of the drivers or the handyman, whatever, using the vehicle without his knowledge.
Without his, that is true,
Yeah.
my lord, but however, my lord, considering that this is a commercial quantity.
Commercial quantity, yes,
And
because that
regarding
observation
the-
has to be made regarding 30,000.
Regarding genuineness of this document, my lord, annex, otherwise, my lord, anybody, my lord, later will come
Hmm.
by saying that I am the owner of the.
No,
vehicle.
no, for,
His
we,
name is
let us
not
go
there.
by the FIR. FIR, there's, except for this, there's no reference that, anyway, I think it will
And
be justified.
In many of the, my lord, NDPS, it happens that, my lord, initially the.
No, it is not, it may be,
Owner
the
of the-
owner may be the kingpin, but
yes.
his name may not come initially. So
Initially.
initial stage, we have
Lordship,
see.
may I submit one thing, Lordship? If Lordship pays the condition number 2, the vehicle and a driver should be available at the site location for 24/7 basis. That means, Lordship, all the time the vehicle is kept by the them, Lordship. And if I am not allowed to record my statement, Lordship, then
No, that will facilitate the investigation.
yes, Lordship.
That would be helpful for the investigation.
And Lordship, I will cooperate with the investigating agency, Lordship. I will record.
No, Mr. Prosecutor, that will be helpful for the industry. Let him record.
Yes.
And then if his implication is found, then of course
Yeah.
37 will have
Yes,
to be determined.
And my lord, regarding the genuineness of these documents.
Yes,
can
Yes,
we-
yes,
Yes, to
yes, yes.
Because otherwise, you see, it will be highly risky to do any kind
Yes.
of transport business.
Yes.
Yes.
Because somebody might,
Yes.
and then I will be
Yes.
inside. The 482 bail application. Action with Neelam Bazar, PS case number 89 of 25, under 21C25 NDPS Act. The case arose out of an FIR dated 36/2025, lodged by police officer of Neelam Bazar PS. The allegations are that upon source information, a checking was laid on NH, at the stated place of occurrence. And
Sorry for
the
interrupting.
vehicle, a vehicle, Bolero vehicle bearing registration number TR01M2262 was found coming from Sri Bhumi side to Neelam Bazar via NH08. Upon checking the same, contraband in the nature of suspected heroin was found, and the weight of the same was found to be 870.07 grams. All the 4 persons in the vehicle were apprehended, and these are the FIR named persons as of now. Full stop.
Well, I would just like to point out one thing only. Well, he has submitted that his Zimma petition was rejected by the trial court. And on the thereafter, police is in search of the present petitioner. But in this petition, my lord, he has not annexed that.
No,
Zimma
that may
petition.
not be
Rejection.
accorded, Lordship. That may not be accorded. Against that, I have already.
On what
recorded
ground that Zimma petition was rejected?
The separate petition has been filed before the Honorable Court.
The present petitioner is stated to be the owner of the Bolero vehicle and had given the same for hire to one Narula Infrastructure Private Limited. Stop. There is no allegation per se against the petitioner / owner in the FIR, nor is he named therein. Here is the registration certificate, copy of the registration certificate annexed. Learned Counsel submits that the prayer for interim custody of the vehicle made by the petitioner before the learned court below was rejected.
And a revision petition is filed before this Honorable Court. Lordship.
Anyway, it is the initial stage
Yes,
of
yes, Lord.
investigation.
Yes,
The court will
Since-
not be
since-
able to give Zimma at this stage.
Since my man.
Vishal Day's case, is there.
Yes, yes.
The initial stage commercial quantity.
Yes, Lordship.
Yes.
That
I
is
think court was prima facie
Yes, that is
justified.
true. But my lord, he has not annexed that over.
That's not an accident. Anyway, so considering the penal provision of NDPS Act given at this stage, the applicability of section 37 have to be seen. However, on the basis of the materials available at this stage, it cannot be said that or you write it the other way. Perhaps it can be said that the test of Section 37 NDPS Act is passed in favor of the owner as of now. Only then I can give this,
Yes, yes.
because otherwise, without
Yes,
this
Lord.
observation, I
Yes,
cannot.
yes.
Statutorily barred. Case diary being necessary, call for the case diary of Nilam Bazar PS case number 89 of 25. However, in the aforesaid facts and circumstances, and in the backdrop of the above discussion, dash the diva. It is, I'm of the considered view that the petitioner should be given an opportunity to record his statement and submit necessary documents. Accordingly, in the interim, in the event of his arrest, 50,000 is one unit, subject to the conditions that he shall cooperate, render full cooperation to the investigation. Semicolon, he shall appear before the IO, making himself available for examination. He shall not hamper or tamper with evidence or try to influence witnesses. He shall not misuse his liberty to commit any illegal activity. List the matter.
On my lord, 3110.
Don't give it on 3110. 3110.
It's from Sri Shivam.
I will be half day leave actually.
Oh.
To both.
On my lord, 2910. 29.
2910.
29.
29.
29.
Deeply overflow.
Mhm. It will, no? Maybe.
और बिल देखो हाँ बिल है और 66 point.
এটা না দুটা। Just a minute, see what the matter is.
479 subsection 2 of verse 17 A to the 5 প্রথমত আমরা কেন্দ্রটা করে লিখে দিব 479 subsection 2
We have to take up the IA.
My lord, first the main matter,
Main
the
matter.
I was yes. My lord, this is a
IA is for what? Just asking.
my lord, in the first order, inadvertently some factual errors had crept
that's
in.
okay.
And also I've also adduced certain additional documents to buttress the point that they had alleged that we had prior criminal antecedents. So to just rebut that, I have annexed a few documents, my lords. My lords, this is an anticipatory bill application where the charges are under 61(2), which is criminal conspiracy. 3082 of VNS, which is extortion, which carries a maximum punishment up to 10 years and fine. Section 351, clause 3 of BNS, which is criminal intimidation, with a maximum punishment of up to 7 years. And Section 67, capital of the IT Act, which regards publishing or transmitting of materials containing sexually exploitative explicit act in electronic form. This is punishable up to 5 years. So, my lord, except Section 308, clause 5, all the offences are up to 7 years or below that. That is the gravity of the offense, my lord, that we are dealing with in this present petition. Now, if my lord kindly peruses page 16 of my bail petition, which is the FIR, there are 4 persons who have been roped in this FIR. Today, my lords, the accused number 2, Augustine Kramsa, and accused number 4, injured Tiso, is before your lordship. The other 2 are already in custody, I'm told. Now, my lord, this is quite a long FIR, but to put it in a short.
Very long also. You want me to read it? I
but-
can read it.
Yes,
I'll
I'll
let-
read it, my lord.
Let me read it also. I'll read it.
Yeah, very good.
Okay, I've gone first.
My lord, now if I may draw certain points to your lordship's attention. The first thing, my lord, the first time they say the incident of honey trapping had occurred in the month of August 2023, my lord. So that was the first time when allegedly they had received a threat. Not from me, my lord. From one Midalin Terongpi, which is the accused number 1. Then, my lord, they go on to say that he was honey trapped in his own flat in Guwahati. And there he went to his family, and after extended period of discussions, they finally decided they will not approach the police. My lord, let me remind myself as well as this honorable court that the informant here is the son of a sitting MLA. And my lord, he is a person who is a public representative and has considerable influence and sufficient power in a manner that he is not supposed to be scared of approaching the police machinery, my lord. That may be kindly noted. Then, my lord, the first instance where we have been named, there is no timeline, my lord. We only know that in August 2023, this particular lady had honey trapped this gentleman, the MLA, and thereafter he had deliberation. He decided that we'll not approach the police, and then suddenly I come into picture, my lord. I'm Augustine Kramsa. My lord,
This bail is only for Augustine Kramsa?
no, my lord, 2 persons.
2 persons.
Accused number 4 as well, Injoy Tiso. He is, my lord, my business partner. My lord, by way of a background, Augustine Kramsa is also a BJP leader. He is holding the post of district president of Minority Morcha. And
Where is this?
the informant's father is the BJP MLA. My lord, the
Both are
first,
from the same party.
yes, my lords. However, my lord,
That's another matter.
yes, the problem here is, my lords, that I had sought a ticket for the assembly elections, and that is where the bad blood had started. Because he is the incumbent MLA, he would of course want to retain the seat, and it's the same ticket that they are vying for. Be that as it may, my lords. The first time I figured there is no timeline, they just mentioned one ex-militant, namely Augustine Kramra, rang up my father one day and informed my father that there should be a meeting amongst him and my father, as the footage of the videograph in question was also in possession of Augustine Kramsa, and as well as in possession of Peter Tiso and Ingzoy Tiso. That is where it begins, my lord. Before that, there is no doubt that the footage is apparently with Midalin Tirongpi, who had recorded it. So, my lord, she is the first source. Thereafter, my lord, the next allegation is that Augustine extorted in total rupees 30 lakhs in 2 installments from my father in Karbi Anglong. Then, my lord, at page number 17, my lord will look at the second para, which starts at the lady who honey trapped my father. My lord has that part. Page 17.
Okay.
The lady who honey trapped my father by the name of Srimati so and so has been in contact with my father prior to the honey trapping occurrence, seeking help from my father, and my father obliged her by paying paltry sums of so and so on early occasion for providing her succor because of her poor financial condition. So, my lord, this lady is known to this gentleman way before 2023. Now, my lord, perhaps then this video could have been recorded any time before that. We do not know. The FIR is silent on that, my lord. Is there any link to show when that footage had allegedly come to my possession? No whisper on that, my lord. They said that they have paid me 30 lakhs. Is there any whisper in the FIR when it was paid, my lord? The timeline is silent. Then they suddenly point out further, my lord, in that paragraph, at the instance of Augustine and upon threats subsequently by the lady. Now the lady comes in for the first time. My father also paid 28 lakhs in total in 3 installments. Out of fear, my lord, he's an MLA. Out of fear that the videograph in question was not to come in public domain in the manner as threatened. Therefore, total 50 lakhs he claims has been paid. Then the next para, my lord, is somewhere we get some sort of an idea of the timeline where he's alleging. My lord, the fourth line, the last part, the fourth line, the extorted amount of rupees 28 lakhs was paid to Srimati so and so in the year 2025 in Karbi Anglong. Now, my lord, all the way from 2023 till 25, she had the video and she never demanded the money. And out of nowhere, in the year 2025, my lords, no date mentioned, no month mentioned, just in the year 2025. My lord, if someone extorts money out of me, and if I succumb to that pressure and I pay the money, if anything, my lord, I surely remember the date and time when I have done it. That has not been mentioned. I'm not bothered about that, my lord. When it comes to my client, my lord will read further. And the extorted amount of rupees 30 lakhs was paid to ex-militant Augustine Kramsa in his coterie in Karbi Anglong, and in totality, entire quantum of extorted amount to the tune of 58 lakhs. Now, my lord, when it comes to me and Enjoy Tissot, the accused number 4, again, there is no timeline. They do not state when they have paid me the money. They say that that lady has been paid in the month of August, when she had a video way back from the year 2023. And at no point, my lord, it has been mentioned when that video had been transferred to me. When they talk about my client allegedly ringing him up and demanding money, they do not say at what point of time had he called. Was it in the year 2023? Was it in the year 2025? If at all, what date and time? That is silent, my lord. Now, my lord, my submission is this. This is a very haphazard FIR where the only to keep the cause of action, so to say, alive, to explain his delay of not approaching immediately in 2023, they have concocted the story and just put in a timeline of the year 2025, and that too against the lady, that she had received the money in the year of 2025, to allege that the cause of action is surviving, and now that the video is out in the public domain, therefore he has come out to give the FIR. My lord, if at all a political leader, my lord,
Video has come out in the public.
yes, he should have come immediately, my lord, when he had come to know about that honey trapping incident way back in 2023. Why did he have to wait for it to be leaked out? And my lord, where am I coming into all of this? The only thing that I see here is that the lady had it, the lady had demanded the bribe, the lady had been paid that extorted money in the year 2025. I am only in between, my lord. It's not mentioned when I have received it, when I have given them the threat call. It's vague, my lord. And they have also invoked section 67A. Now, my lord, for that, there has to be a transmission from my side. There has to be a publishing from my side. Is there anything, my lords will look into the case record, of course. Is there anything to show that that alleged honey tapping video had been published by me?
But elements of extortion.
My lord, the
Extortion,
elements of
okay.
extortion.
That's the BNSS section.
Yes, my lord. These
IT
have,
Act is the transmission part.
yes. There's nothing to show that it has been done from me. But extortion, they have said that I have threatened them.
BNSS sections are given for the extortion part.
Yes, my lords. Yes, my lords.
And this is for the transmission.
Yes, my lords. Only 67A of the IT Act.
Yeah.
My lord, they have, of course, they have said that I have threatened them. But my lord, there has to be some specifics. Where do I get the knowledge that when it has happened, how it has happened? There's no timeline, my lord. With regards to that lady, my lord, they have been very careful. they have mentioned. And my lord, why this huge lapse of 2 years, my lord? Is it something that needs to be put a lid on? And my lord, any reasonable person, my lord, if he is paying out of extortion so that the video is not leaked, he will ensure that that video is deleted when he has paid that ransom. If like he should have ensured that if at all his case is true, my lord. Now, my lord, so far the allegations are concerned, my lord, I have already given a background. However, I have one more case that I have pleaded, my lord, in my bail petition. My lord, there is a lady in picture who is who goes by the name of Moon Ingtipi. My lord, now
Additional affidavit.
no, my lord, in my bail petition itself, it is there. My lord, may come to page 23.
22.
Page 23, my lord, annexure 3.
Mhm.
There's a money receipt agreement. Down below is a lady called Moon Ingtipi, Board of Director AHSIDC. Well, she is also a BJP worker. And prior to this incident, my lord, I had a very good terms with her because we are both party workers. And she had sought some money out of me and my wife. She needed it for some purpose, and we had given a total of 2 crores to her. And my lord, as a way of background, Moon Ingtipi, I am told, is the niece of the incumbent MLA. Now, my lord, all the annexures, my lord, turns through the pages. There are a lot of money receipts and agreements, mortgage agreements, where I had paid the money to this Moon Ingtipi. And my lord comes to page 31. It is a check.
Yeah.
Page 31 check. Down below, my lord, on the right hand side of the check, there is a signature of Moon Ingtipi. So she had issued a check of 1,90,000,
1 crore.
1 crore 90,000 as part discharge of the dues that she owed.
30 lakhs.
Yes. But on the very next page is the dishonor memo, my lord. At the down below, my lord, there is a note in handwritten, my lord. It says account number does not belong to Moon Ingtipi. My lord, that is where the problem had arisen. Now, when I had gone to approach Moon Ingtipi as to why have you not dishonored, why have you not honored your promise, then she had said that my uncle is so and so he will repay you the amount. My lord, let alone that, instead I have been visited with this FIR, my lord. So that is what the actual background is. And my lord, I would like to share one particular news item. It is on my lord's whether my lord wants to rely on that. Dilipo. This article is of August 2025. It reads, Assam BJP leader shielded amid scam allegations, victim questions police role. My lord, would go to the next page. It's about Moon Ingtipi, my lord, clearly. Next page, my lord, last line. Local sources also claim that she has continued to receive support from a senior BJP MLA. My lord, that is the link that I'm trying to show. Now, my lord, they have, in response, filed an objection. In the objection, there are mainly 5 key points that I have identified. The first allegation that they are putting is that I am an ex-militant and I have several criminal antecedents. Now, my lord, they have listed around 11 cases which are against me. My lords, I would offer a table of cases. I have given my response.
I have seen it is available in the.
My lord, not all, my lord. In some of the cases, they have annexed the bail applications also. It is not like they have given the final orders. In some cases, they have annexed the FIRs. In some cases, they have annexed some bail rejection orders. That is it. My lord, in the table that I have just given, I have given the status of all the cases. The first case, my lord, is under 341, 392, 506. That, my lord, is a very old case, and I'm told that the matter has already been closed. I've been discharged. So far, my lord, the second case is concerned, I have not been charge sheeted. The third, fourth, fifth, my lord, I have annexed the orders in my IA. I'll come back to that. Then, my lord, number 7, number 6 PRC case is disposed. My lord, now the other point that they have raised is that a proclamation was issued against me in that said case, number 6. My lord, in that case, when the proclamation was served, I was undergoing medical treatment in Delhi. And therefore, of course, it could not be served on me and certain orders were passed. But now I'm told that the matter has also been disposed. My lord, the next case, Difu PS case 154 2020, my lord, that they have alleged is against me. That is in fact against another person by a similar name, who is known as, what is his name? Augustine Crow. Okay. It's Kamsa. Okay. My lord, but this is a different person. Item number, serial number 7. And number 8, my lord, is essentially a civil land dispute that had arisen. And even in this case, Delhi PS case 123 of 21, FR has been submitted. And number 9, my lord, the case was dismissed and it was passed in my favor. And number 10 I have annexed in the IA, my lord, the discharge order. And number 11, my lord, yes, that I had been convicted during my military days, my lord. I have already served a conviction of 1 year. That I'm admitting, my lord. Now, my lord, would kindly come to my IA. My lord, I will just take my lords through the operative portion of the orders. The first case, my lord, kindly comes to page number 9.
It's a judgment.
Yes, my lord. The case FIR number is 37 of 2019, my lord, Delhi PS case, the one they have alleged against us. Now, my lords will kindly turn to the operative portion at page 24. Here I am the only accused. My lord has page 24.
Yes,
My lord, para 40.
acquitted.
Yes, acquitted. Then, my lord, the next case, my lord finds at page number 36, my lords. My lord has page
Yeah.
36, yes. So this is PRC case number 84 of 20, arising out of FIR number 33 of 2019 of Delhi Police Station. Here, my lord finds me as accused number 2. Then, my lords may kindly turn to page number 45.
45 is not there. Oh, sorry.
45, my lords.
Page number 45.
Yes, page number 45. Para number 25, my lord. Final order portion.
Era?
Para 25, my lord. Final order portion. The accused persons A1 and A2 are acquitted. My lord has it.
Yeah.
Yes. Then, my lord, the next case.
That's okay.
Yes. So, my lord, my
Look at
point is
other
that
aspects.
yes, I have been discharged or acquitted in all of these cases, my lord. Therefore, their point of criminal antecedents does not arise, my lord, at this stage. The second issue they are saying is, I'm a proclaimed offender. My lord is aware of the settled law that, my lord, even when there is a proclamation that is issued against the offender, there is no bar for grant of anticipatory bail. My lord,
There is bar. If a person is declared proclaimed absconder,
my lord,
in a particular case.
yes, my lord, but in this case, it is
Another
not.
case, then it will be different.
Yes, my lord, this is another case where I have been declared to be a proclaimed offender. My lord, may kindly, if I may kindly.
That can be taken into account, but the
Yes.
bar would be, I think, with regard to the same case. What do you say?
Yes, of course, my lord. But in this case, I have not been declared to be
But
proclaimed
let's
offender.
focus on this, we should not go too much into other cases, otherwise.
Yes, yes, my lord. My lord, that is their contention.
Use can be prejudicial.
Yes, yes,
Go into other antecedents,
yes,
we should focus on the case at hand.
yes, yes, my lords.
Towards-
Therefore, my lords, my submission here is that, my lord, the points that they have raised in their objection, my lord, do not hold water. My lord, this judgment that I have sent, kindly peruse para 8 and 9, my lord, just for my satisfaction.
Sure.
Yes, yes, ma'am. Para 8 and 9. So, my lords, the objections they have raised, my lords, do not hold water in my submission. And, my lord, so far as my detention is concerned, my lord is aware about the changes that has happened in the CRPC and the BNSS. If my lord peruses the CRPC, I'll just read the relevant portion, my lord. Section 438, my lord.
There is a law which Ashwini Dubey, I think this is, but there's a Ashwini Dubey judgment It
Hmm.
has clearly said that if in a particular case, not from other cases.
Yes, my lord.
If proclamation is issued, then it will not be possible to grant anticipatory bail.
Yes, my
But
lord.
if this judgment has the same quorum,
Yes, yes, ma'am.
conflicts. But we'll have to check.
Yes, my lord.
Dubey, because that was also a Dubey, I think, but Ashwini Dubey, I think.
Yes.
We had used it in one of our orders
Yes.
recently, but I have to cross check. Anyway.
However, my lord, this is not pertaining to this case. This is a different case, my lord.
So this is a different case.
Yes,
So,
my lord.
yeah, we'll let us focus on the.
Yes, my
matter
lord.
at hand.
Section 438, my lord.
We'll lose track.
Yes, my lord. Section 438, my lord, of the erstwhile CRPC, my lord. I just draw one point, my lord. There were certain grounds, my lord is aware under 438 clause 1.
Yes.
If my lord has the CRPC. That is where, my lord, is expressly stated that the nature and gravity of the acquisition, the antecedents of the applicant, the possibility of applicant to flee from justice, etc., had to be considered by the honorable court while considering a case for anticipatory bail. However, my lord now peruses the provision of anticipatory bail under the BNSS, my lord. 438. 432, my lord.
82.
I'll just read the first portion. When any person has reason to believe that he has been arrested on accusation of having committed a non-bailable offence, he may apply to High Court or Court of Session for direction under this section, and that court may, if it thinks fit, direct that in the event of arrest, he shall be released on bail. Clause 2. When the High Court or the Court of Session makes a direction under subsection 1, it may include such conditions in such directions in the light of the facts of the particular case as it may think fit, including a condition that a person shall make himself available for interrogation by the police officer as and when required. A condition that a person shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the facts of the case, so as to dissuade him from disclosing such facts to the court or to any police officer. A condition that the person shall not leave India without the prior permission of the court. Any other conditions. So, my lord, my humble submission is that the factors which were to be taken by the honorable court while considering an anticipatory bail application under the erstwhile procedural law is no longer existent in the current law, my lord. And to buttress my point, my lord, I would merely like to submit a judgment which deals with this issue. This is a judgment of the Honorable Chhattisgarh High Court, my lord.
Okay, let us see that. Statutorily, this has been removed.
Yes,
but
ma'am.
it remains in our case law. actually.
Yes, my lord.
Anyway, this is also significant in a way.
Yes, my lord. Yes,
In a way that it
Therefore,
has
my lord,
been removed.
yes, my lord. Therefore, their arguments they fall flat, my lord. That
So
is my
these
submission.
are, no, but what one cannot say also that these factors are no longer relevant.
Yes, my lord.
Because it exists in our case. law.
Yes. My lords may kindly
I don't
look
know
at
why it was removed.
para 6, my lords. The answer is perhaps in para 6, my lord, of the judgment. My lord has the para. If I may kindly read, my lord. The present bail application has been preferred under section 482 of the BNSS. It is relevant to note that the difference between erstwhile perimeter provision of 438 of
Yeah,
CRPC.
widens that discretion.
Yes, my lord.
This is the thing, widens the discretion.
Yes,
It can be beyond these factors also,
yes, my lord.
beyond these factors also.
Therefore, my lords, the point that I'm trying to impress upon my lords is that all the prior criminal antecedents that are being projected, they are no longer there, my lord. Secondly, the FIR does not contain the key facts which links me to this event. The date on which I have called them with the threat of extortion, when I have criminally intimidated them. My lord, 2023 case, they have mentioned about 2025, no mention of the month date, no specific dates as against me and my co-accused, my lord, as to when I have called them, when I have demanded money, when they have paid me money. Just, my lord, the allegations have been put in a manner so that the political rivalry can be settled, my lord. Because even though we are from the same party, we are now vying for the same election ticket, my lord. And my lord is aware of the settled position of law, my lord, why the anticipated bail provision had come into force. So as to deal with such issues where out of political rivalry, one person is sought to be put behind bars to teach him a lesson. My lord, my submission is that let this case not be such kind of a case where I have been made a scapegoat of a political vendetta, my lord.
Anyway,
That is my submissions, ma'am. Obliged.
This, who's appearing for the prosecution?
My
You are
lord,
appearing.
my lord,
Kesdari has come.
my lord, case they come.
Kesdari has come.
My lord, there are 4 accused, my lord. 2 accused has already been arrested, my lord.
They are in
Yeah.
custody.
My lord, they are in custody. Their statements are there in
And
the
these two are seeking anticipatory.
ancillary bail, my lord. And my lord, the case diary reveals that the petitioner, my lord, he's a criminal, many criminal activities are there. His antecedents are criminal activities are there. And he has already been charged and cases are pending against him. And he is a known criminal, my lord. And there is a land grabbing cases are also there against the petitioner, my lord. And for that purpose, my lord, that lady, my lord, she was arrested. Her statement was recorded. And her statement
Which
is,
lady? This lady,
my lord,
accused lady.
accused lady was arrested, who was placed before the, my lord, particular person, my lord, regarding that MLA, my lord. And she herself stated that the 2 accused, my lord, by putting gun on her, my lord, they place her to the MLA's place, my lord, and they are extorted, and subsequently they extorted the money, my lord, from the, my lord, person concerned. And she reveals that when the persons have the criminal antecedents, my lord, and the charge-sheeted person, my lord, whether lordship will consider an anticipatory bail at this stage. Lordship will look into the, my lord, provision of section 479 2, my lord. BNSS.
479 2.
479 2, my lord. Notwithstanding in subsection 1 and subject to the 3rd provision thereof, where an investigation, inquiry, or trial in more than one offence or in multiple cases are pending against a person, he shall not be released on bail by the court, my lord. So, my lord, there are cases, my lord, lordship, in the, my learned friend has stated that some cases he has been acquitted, but there are some other cases also, my lord. In most of the cases, armed sector is there, my lord. So, my lord, that theory, that projection that he has put the person in threat of the, my lord, by way of arms, my lord, that is there in the case diary, my lord. Lordship may peruse the case diary also, my lord. I have the flag mark that the version in the Karbi language, my lord, that has been translated, my lord, that has been specifically stated about the involvement of the person who was arrested and the petitioner, my lord.
You are appearing for the informant.
My lord, my role, my lord, with all respect, my lord.
Green mark is the, my lord, the statement which is, my lord, that that statement of the Karbi language that has been translated by me.
It's okay, no problem. I'll go through it.
And my lord, that particular mobile phone that has all been seized, pen drive is there, everything is there, my lord.
My lord, may I add a line?
Yeah, please submit.
My lord, my role is, my lord, it is not by the statute, my lord, but because of an authority, my lord, with all respect, my lord, that a victim can even participate at the stage of grant or non-grant of bail, my lord. May I just read that paragraph, my lord? It will take one. My lord, with all respect, my lord, Jagjit Singh, as reported in 2022 9 SCC, my lord, page 321. And the relevant paragraph is, my lord, with all respect, my lord, 23, my lord. I'll be very quick, my lord. I'll read it out, my lord. Then I.
Para 23.
My lord, there in that para 23 states, my lord, with all respect, my lord, victim within the meaning of then it was CRPC, my lord, in 2022, my lord, cannot be asked to await the commencement of trial for asserting her right to participate in the proceeding. She has legally vested right to be heard at every step post the occurrence of an offense. Such a victim has unbridled participatory right from the stage of investigation till the culmination of the proceedings in an appeal or revision. Thereafter, my lord, para 24(2). Second, where the victim themselves have come forward to participate in a criminal proceeding, they must be accorded with an opportunity of a fair and effective hearing. Have I made my position clear, my lord? It is even at the stage of, my lord, with all respect, my lord.
No dispute over this fact.
These two, my lord. Now, my lord, here what has happened, my lord? In their bail application, first, my lord, they have stated in one paragraph, and Supreme Court, my lord, Apex Court, my lord,
has clearly nullified that, my lord. In their paragraph, they have stated, my lord, in their amendment, occurring at
Page 6,
page 6, para 5, my lord. One must come with clean hands, my lord.
page 6,
Page 6, para 5, my lord.
of the bail petition, right?
Bail application. My lord. On this ground itself, it doesn't sustain, my lord. Page 6, para, lordship may have,
Page 6,
para 5, my lord.
5 is here.
That the complainant has falsely implicated the petitioner in the present case. The petitioner is a respectable citizen of the society and is not involved in any criminal case. Lordship has seen, my lord. And my lord, he has got as many as 11,
We have given 11, out of which 4
11 cases pending. And my lord, in their counter affidavit, they have said that out of those 11, only 4 have ended in FR or acquittal or in conviction, my lord. Have I made my position clear?
Yeah.
7 are still pending apparent. I'll place it, my lord. So this is a paragraph, my lord. On this, my lord, the application does not sustain because on this, what the apex court has said, my lord, 2 authorities, my lord, with all respect, my lord. One is 25, latest, my lord, Munnish versus State of Uttar Pradesh, my lord. There I read, my lord, with all respect, my lord. Para 8, my lord. Had the petitioner's criminal history been disclosed in the special leave petition, lordship may not have found it, my lord.
Come here.
Munnes, my lord, with all respect, my lord.
Oh. Para?
Para 8, my lord.
Yeah, go ahead.
May I
Had the
just
peti-
begin, my lord?
had the
Had the
petitioner-
petitioner's criminal history been disclosed in the special leave petition, we wonder whether notice on it would have at all been issued. Meaning thereby, my lord, had it been gone to the notice of the court that there were criminal cases pending, then even notice would not have been issued, my lord, in that particular case, my lord. Have I made my position clear, my lord? Thereafter, my lord, 9, my lord, be it as it may, since the petitioner, may I, my lord?
Yes.
Since the petitioner has suppressed material facts, here suppression, my lord, they have come on their own, my lord, that there are 11 cases pending. With regard to the involvement in criminal cases, he is not entitled to the discretionary relief of bail. There it goes, my lord. Thereafter, my lord, with all respect, he goes in paragraph 12 is also speaking, my lord. Subsequent to this, my lord, the same authority, my lord, with all respect, my lord, the apex court has deprecated, my lord. This is Kaushal Singh, my lord.
Latest case?
Latest, my lord, 2025, SCC online, SC 1473, my lord. They are, my lord, with all
147.
my lord.
You give me a copy, right? Copy.
Copy has been placed, my lord.
Oh.
Mo puri pe. Tate ase dada uliai di apna kindly. Para 22, my lord. That it should gun down to the, it must percolate down to the high courts, my lord. Para 22, my lord. May I read it, my lord? May I, my lord? Before parting, we'd like to state that accounting for the criminal antecedents of the accused while considering the bail applications has been the subject matter of concern for courts across the country. The rules and orders of the Punjab and so High Court are specifically provided as below. It is given there so far as Punjab is concerned, my lord. Para 23. We feel that every High Court in the country should consider incorporating a similar provision. Have I made my position clear, my lord?
Yeah.
So the first authority will prevail. If one doesn't come with clean hands, my lord, that itself, my lord, with all respect, my lord, the batsman is bold, my lord. Have I made my position clear, my lord? This is the law, my lord. Thereafter, my lord, certain things, my lord, I'll be very cryptic, my lord. With all
It
respect,
has
my
been
lord.
recommended to incorporate similar provision like Punjab and
Exactly.
Haryana.
But the first one, apex court has said, my lord, that, my lord, in that particular case, it was not granted. Have I made my position clear, my lord? It was, what is the law there in Supreme Court? It should be the law by incorporation in the High Court rules of respective High Courts, my lord, down below, my lord, with all respect, my lord. So their paragraph my lord, with all respect, my lord, that no criminal case is pending on an affidavit, my lord. And thereafter, they file an affidavit when we say that 11 cases are pending, that they are, my lord, with all respect, my lord, 4 is not there, 7 still remains, my lord, with all respect, my lord. And now, my lord, with all respect, my lord, out of in those 4 cases, whether got acquittal or whatever be it, my lord, just for antecedent part of it, my lord, Lordship, may I kindly have a look at page 75 of a bail order, or my lord, we are rejecting a my lord bail for this accused, my lord, in a case, my lord, that occurs at page 75. We have annexed it, my lord.
Of your
My lord, we additional affidavit, my lord, in the anticipated bail application, my lord. Additional affidavit we have filed. my
page
lord.
75.
Page 75. There, my lord, para 9. It bail dia order and bail rejection. Comes as that one accused, my lord, who is seeking.
Rejection order.
I'm reading that, my lord. That shows everything, my lord. His antecedents, my lord. Page 75, para 9, my lord. As regards the criminal case, petitioner has produced a copy of judgment so and so, so and so, so and so, which goes to show that a said case was registered on the allegation that the petitioner, along with his boys, abducted one person on gunpoint, and subsequently dead body of the person was recovered and charge sheeted so and so, so and so. Thereafter, after trial, the accused petitioner was convicted under section so and so, sentenced him to pay a fine of so and so, in default simply in imprisonment for 1 year, however acquitted from rest of the charges. Have I made my position clear, my lord? This is the antecedent. Thereafter, my lord, with all respect, my lord, Lordship, may kindly have a look at, my lord, with all respect, my lord, page 67, my lord, of this application, 67 to Jason.
Of the additional affidavit, right?
My lord, additional affidavit neki?
67 is another bail order.
Rejection order, my lord.
Order.
No.
No, is different.
69 is the effective order, my lord. My lord, there are several orders we have annexed, my lord. Now let me not harp on it, my lord. And the cases pending against page 44, my lord. Lordship has seen, my lord, that they had no criminal case. When we pointed out, they come up with a rejoinder that 4 are gone, my lord, 7 remains. Page 44, these are the cases, my lord, from 1 till 11, my lord. Have I made my position clear, my lord? And in their counter, my lord, they have stated that in 4 they have been acquitted or discharged, my lord. 7 are still pending, my lord.
Okay.
Another aspect, my lord. First, they sought bail. You cannot send your stand. One day you take a stand, second day you don't take a stand, my lord. Initially, they took a stand that he was pretty sick. Even his, my lord, which were 39 level was 11, my lord. So that was placed before the court. The court considered, and what the court wrote, my lord, in the order, my lord, with all respect, my lord, on day 1, my lord, it is in the order of first order, my lord, on 26/9, my lord. And now they keep mum, my lord. They don't seek on medical ground, my lord. 26/9 order, my lord. First order, my lord, of the, that will be the record, my lord.
Seen it. This one is, I've seen.
My lord, that bail application, my lord.
Yeah.
There are
26/9.
26/9, there in paragraph. Medical project. My lord, there, para 9, my lord, kindly see. His Cat9 level was 11. Then court passed this order, my lord. It's a judicial order, my lord. However, looking into the medical condition of the accused applicant number 1, this court directs that in the event of his arrest, the arresting authority shall provide the necessary medical attention to the accused applicant number 1. Have I made my position clear? That stand is not taken today. Now they have annexed not medical certificates, my lord. Earlier time, medical certificates were annexed. 39 level was 11, my lord. Very high, my lord. And now they have given, my lord, one bill from Dimapur Hospital, meaning thereby, he is there in Nagaland, my lord. With all respect, my lord. In the IA, my lord, their IA. And no medical documents, my lord. It shows that was just taken, medical ground was just taken, my lord. Page 68 of their application, my lord. It's a bill only, my lord. No creatinine level, nothing, no medical ground now, my lord. Can it happen, my lord? You eat the cake today. Have I made my position clear? You cannot eat the cake and have it too, my lord. Page 68 of their application. Now they add, my lord, with all respect, my lord, one medical beam from Dimapur. That he is at large in Dimapur, it is apparent. Have I made my position clear, my lord? So this is the sequence, and thereafter, my lord. I'll go. Another aspect, my lord, regarding proclamation, my lord.
No.
Regarding proclamation, we have given it specific, my lord. When one is a proclaimed offender in a case, he cannot get bail in that case, but the tenor remains. A man who is having 11 cases pending against him, in one still a proclamation is arrested. See his power, my lord. Have I made my position clear? He has not been booked, and in another case, he is seeking pre-arrest bail. I'm not saying the law is this, that in a case wherein he is not a proclaimed offender, he cannot seek pre-arrest bail. He can.
Discretion should not be exercised.
Exactly, my lord. There, my lord, the proclamation is pending. That occurs at page 85 of our application. Our additional affidavit, my lord. That proclamation is pending, my lord. And, my lord, the authority that has been placed, my lord, regarding proclamation, my lord, that it can be granted. That is of 2 judges' bench, my lord. And this, my lord, with all respect, my lord, that it cannot be granted in the case in question, but a tenor remains, my lord. This is Prem Shankar Prasad, with all respect, my lord, same, my lord, because this is our copy we have placed, my lord. This is 2022, my lord. This 2022 will prevail, my lord. That, my lord, Nia case, my lord, our division bench, my lord. This will prevail, my lord. And there it occurs at para 16. I should not read it, my lord. If I read, to read apparent, my lord. Lavesh is quoted, my lord. And thereafter the last parting line, my lord. My lord, it all absconding, my lord. We reiterate that when a person against whom a warrant has been issued and is absconding or concealing himself in order to avoid execution of warrant and declared as a proclaimed offender in terms of section 82 of the earlier 82, my lord, of the code, he is not entitled to the relief of anticipatory bail. So this should be the law in India, my lord, in the Indian criminal justice delivery system, because it has same stand and 2022, my lord. Otherwise, the rest one would be pari curiam or subsequent, my lord. So then it would not be applicable, my lord. With all respect, my lord. And that is why, my lord, that this authority would prevail, my lord, seeking pre-arrest bail in a case wherein he is a my lord, proclaimed offender, it cannot be granted. That's the law. But if a man has 11 number of cases or as many number cases, and in one he is a proclaimed offender, and he is seeking relief in a different case, it is not, the statutory bar or legal bar is not there. But the mandate remains that in one he is a proclaimed offender. In this case also, after getting bail, that he would appear or he will not abscond and he will not become a proclaimed offender, that my lord, that part, my lord, would not vanish into thin air, my lord, with all respect, my lord. And because the subsequent judgment of 22 that I have quoted would prevail is apparent from, my lord, that 48 part, my lord, dealt with by a division bench of our High Court, my lord, because Dhanesh and everyone, my lord, there it is quoted. The judgment is, my lord, with all respect, my lord, National Investigating Agency, Bhatat Thanglingman Mate, my lord. My lord, Criminal Appeal 234/25. I am reading only para 15 and the line, my lord. Para 15, my lord. There, my lord, it has been quoted, National Insurance Company versus so-and-so, wherein it was held that if there are conflicting decisions of equal benches of the Supreme Court.
The earlier one would prevail.
Exactly, my lord. The earlier decision should be followed by the High Courts. So, my lord, this is set at rest, and the material against him, my lord. Of course, my lord, this is yes, I have no access to the case diary. This man, kindly see, my lord, both brothers coming together in a pre-arrest bail application, my lord. Named accused person, my lord. Meaning thereby in the same application, they know each other. Have I made my position clear, my lord? Hand in glove. This is the factual matrix, my lord. two accused male persons named in an affair, they approached this honorable court together, my lord. And the allegation against Kramsa, one of the accused seeking pre-arrest bail, my lord, is this that, because it is published in, I do not, I'm not relying on it, but it must be that a girl's statement, my lord. See, everywhere, it is in everybody's mouth. And what I came late because I'm 72 years of age. I maybe have some fun and frolic. That's different matter, but money cannot be extracted like this. And my lord, this video, my lord, at this gentleman's behest, lady cannot do it, my lord. Having fun and frolic and photographing, my lord, at the behest, and
This is a moral
ultimately
issue. This is a legal issue.
at gunpoint, Kramsa took that, my lord, clip. Kindly, my lord.
According to her statement.
But this is publicized in news. I do not have access to that, my lord.
The public prosecutor has submitted that.
My lord, exactly, my lord. Then what remains more? This is my case, my lord, with all respect, my lord.
My lord, if
And
I-
regarding antecedents, my lord. Niro Jadhav, my lord. Niro Jadhav, this is 2016, my lord. 2016, 15 SCC, they are para 15 I am reading out. I'll be very cryptic, my lord. This being the position of law, it is clear as cloudless sky that a high court has totally ignored the criminal antecedents of the accused. In a particular case where a high court granted bail, my lord, criminal antecedents of the accused. What has weighed with the high court is the doctrine of parity, a historicity involved in the nature of crimes, which we have reproduced herein above. Here there are 11, my lord, are not minor offenses so that he is not to be retained in custody. But the crimes are of heinous nature, and as such crimes by no stretch of imagination can be regarded as jejune. Such cases do create a thunder and lightning, having the effect potentially of torrential rain in an analytical mind. The law expects the judiciary to be alert while admitting this kind of accused person to be at large, meaning thereby they are to be in custody. And therefore, the emphasis on existence of discretion judiciously and not in a, of course, I will not go further, my lord.
479,
And 479, my lord.
1 to 4.
479, why am I
This is
reading out, my lord?
Niru Jadhav, no? Niru Jadhav.
Niru Jadhav, my lord. 479, my lord, this is in the statute itself, my lord.
Yeah, 479.
479, one I am reading out, my lord. I'll be very cryptic, my lord.
This is a beneficial provision.
This is a beneficial provision, my lord.
479 BNSS.
When bail needs to be granted, my lord, if he is in custody,
Even after conviction.
even after conviction, my lord, where a person has, during the period of investigation, inquiry or trial, under this Sanghita of an offense under any law, not being an offense for which the punishment of death or life, not that 90-day period offense, undergo detention for a period extending up to 1/2 of the maximum period of imprisonment specified for the offense under the law, he shall be released on bail Have I made my position clear?
67 to earlier. Yeah.
Have I made this beneficial provision, meaning thereby?
It was earlier 436.
Exactly,
A,
my lord.
A.
Exactly, my lord.
Captain open for
Exactly. And the new part incorporated is 2, my lord. Even therein, my lord, that quantum
part is there.
he has to undergo, my lord. Have I made my position clear, my lord? 2 I am reading out, my lord. 479 2, my lord. With all respect and folded hands, my lord, notwithstanding anything in subsection 1 and subject to the third proviso thereof, where an investigation, inquiry, or trial in more than one offense, 11 cases pending, foregone, my lord, or in multiple cases are pending against a person, he shall not be released on bail by the court.
This is regular bail.
This is regular bail.
As regards
Where, my lord, with all respect, my lord, this is pre-arrest bail. It would be more, should be more in operation, my lord, as a student of law, my lord. With all respect and full hands, my lord.
My lord, if I may quickly rebut, my
Yeah,
lord.
you can reply. Yes, madam.
First, my lord, may I submit a judgment, my lord? Lordship's kind perusal. My lord, this is the very recent judgments, my lord, of the Honorable Apex Court. This deals with the issue of whether the statement of the co-accused can be relied, my lord. My lord, may I kindly refer to para number 53, my lord?
Yes,
Point number 4, my lord, on the next page, page 28.
just a minute. To reply. Krishna Mohan Reddy.
My lord, have,
Para?
para number 4, my lord, page 28. Para 53, number 4, my lord.
You just kindly tell me the page?
Page 28, my lord.
20. First let us. see
Number
page
4, my
number.
lord. My lord has it.
Yes,
Page 28, number 4, my lord, point number 4.
yes.
Where a police statement of an accused is a confessional statement, the rigors of section 25 and 26 respectively apply with all its vigor. A confessional statement of an accused would only be admissible if it is not hit by sections 24 or 25 respectively, and it is in tune with the provisions of 26, 28, and 29 of Evidence Act respectively. Then, my lord, the operative part. In other words, a police statement of an accused, which is in the form of a confession, is per se inadmissible, and no reliance whatsoever can be placed on such statements either at the stage of bail or during trial, my lord. So, my lord, we are at the stage of bail here. So, my lord, the learned PP has submitted that the co-accused has implicated me. Of course, my lord, should implicate me. But whether my lords at this stage can look into it, my lord, as an admissible statement on the basis of which my culpability can be decided, my lord. That is one issue. Then, my lords, my learned senior had submitted a few judgments on that if there are prior criminal antecedents, then that has to be looked into. My lords, may I submit 2 judgments on that point, my lord? Of course, my lords, these are division bench judgments. Nevertheless, my lord, para number 5. My lord, first one is Prabhakar Tiwari. My lord has it.
Yes.
Para number 5, my lord.
Yes.
We have considered the respective submissions. The facts highlighted by the appellant are that the case involves offense under section 302, read with section so and so of the IPC. The accused has several cases pending against him and has been named in the statement forming the basis of the FIR and on the date of the occurrence itself. 2 individuals so and so whose statements have been recorded under 161 of the 173 also refer to the involvement of the accused Vikram Singh. Then, my lords, will come to para 7. On considering the submissions of the learned counsel for the parties, having regard to the circumstances of this case, in our opinion, there has been no wrong or improper exercise of discretion on the part of the High Court in granting bail to the accused. The factors outlined in the case of Mahipal for testing the legality of an order granting bail are absent in the impugned order. The materials available do not justify arriving at the conclusion that the order impugned suffers from non-application of mind, or the reason for granting bail is not borne out from a prima facie view of the evidence on record. The offense, my lord, this is important. The offense alleged no doubt is grave and serious, and there are several criminal cases pending against the accused. These factors by themselves cannot be the basis for refusal of prayer for bail. The High Court has exercised its discretion in granting bail to the accused Vikram Singh upon considering the relevant materials. So, my lord, this is the position. Then, my lord,
Legal part.
yes, my lord. The other portion is, my lord, Maulana Muhammad Amir Rishadi. Para 6, my lords. Just one paragraph. Para 6, my lord, has it?
Yeah.
Yes. It is not in dispute and highlighted that the second respondent is a sitting MP facing several criminal cases. It is not in dispute that most of the cases ended in acquittal for want of proper witness or pending trial. As observed by the High Court, merely on the basis of criminal antecedents, the claim of the second respondent cannot be rejected. In other words, it is the duty of the court to find out the role of the accused in the case in which he has been charged and other circumstances such as possibility of fleeing away from jurisdiction of the court. So, my lord, my respectful submission here is, my lords, the criminal antecedents, I have come clean with it, my lord. I have submitted detailed affidavit with the orders. I have been acquitted, and the rest I have submitted in the detailed table, my lord, has it. My lord, I may have prior criminal antecedents, my lord. I'm a public figure. I'm a political person. My lord is ever against a political person. So many cases are filed.
This proclamation, it is still pending. proclamation.
My lord,
Been declared a proclaimed absconder, right?
he was
In
because,
one case, he should appear in that case then.
yes,
He should
my lord, this is an old case. I do not have instructions, but I've been
No,
told
no,
the case has been closed.
You cannot say, I mean,
Yes,
no instruction, how can you
Yes,
say?
my lord, that is an old case,
Just ask-
nevertheless.
Generally ask.
Yes, my lords will kindly focus on the facts of this case and the role of the
Because it
accused
will
in.
look very contradictory.
Yes, yes.
One court, same court is court, right?
My
One
lord, my lord.
Case before one court, I am a proclaimed absconder. Another one, I am seeking
My lord,
anticipatory.
what I have
That's a
been, yes.
bit of a problem.
Of course, my lord, I bow down, my lord. But what I've been told was that on that particular date, he had gone for a medical checkup. I have that list, if my lord wants to.
Whatever, he
peruse.
should bring it
Yes.
for the notice of that court.
Of course, my lord, that since I don't have the instructions, I would not submit on that, my lord. My lord, there's one more judgment that I would finally like to rely on, my lord. Just one moment. এখন দি দিব। This is a 2011 judgment.
This is
Division
the
bench.
Maitre case, no? Where
Yes, my lord.
anticipatory.
My lord, may kindly come to para 109. It's towards the end, my lord.
Many of these principles have been now incorporated in the subsequent decision.
Yes, yes, ma'am.
Susila.
Yes, my lord. Yes.
109,
Well,
but
yes.
still this is a very important judgment.
Yes, my lord.
on
May I read,
anticipatory
my
bill.
lord? A good deal of misunderstanding with regard to the ambit and scope of section 438 CRPC could have been avoided in case the constitution bench decision of this court in Gurbakh Singh Sibia was correctly understood, appreciated and applied. The court in Sibia case laid down the following principle with regard to anticipatory bail. Section 438(1) is to be interpreted in light of Article 21 of the Constitution of India. Filing of FR is not a condition precedent. Order under 438 would not affect the right of police to conduct investigation. My lord, this is one important thing that I would like to impress upon my lord. Even if I am granted an anticipatory bail, my lord, the investigation will not stop. In fact, I have given an undertaking that I will appear and cooperate. My lord, therefore, the grant of anticipatory bail to me in this case, my lord, is not going to in any way affect investigation.
No, it does not stop investigation, but it puts some restrictions on investigation.
My lord,
Because custodial examination can.
yes,
never be-
my lord, I'll be
And he's
subject.
on bail.
I'll be subject to whatever restrictions my lordships puts. And my lord, so
Oh,
far
that's
as
fine.
the non-disclosure of the medical reports are concerned, my lord, as my learned senior has submitted, my lord, I have already annexed it in my IA. Inadvertently, I forgot to submit some time before. My lord, may kindly come to page 59 of my IA.
Just a minute. Take this. Of your IA.
Of my IA, my lord.
So quite a like, right? Thank you. Page?
Page 59, my lord. My learned senior had submitted that I have only annexed the bills. My lord, respectfully, my lord, page number 59, page number 60, these are the reports, my lord. These are pathological reports. This is the updated one where my lord would kindly look at the creatinine levels, my lord. This is the updated one, 8/10/2025, 11.6. Down below, my lord, HB percentage 6.6. Next page, my lord, uric acid and all of that are my lord. It's very complicated, my lord. My lord, he is a person who needs medical attention. And my lord, also in Gurbakh Singh Sibia, my lord is aware, a person who is free, my lord, is in a better position to defend this case. And my lord, liberty is of utmost importance, my lord. Of course, my lord, the purpose of anticipatory bail is that the court may give whatever reasonable restrictions the court deems fit, so that I am not able to hamper temper witnesses or evidence. But my lord, to the extent that I am able to appear for the investigation, my lord, to that extent, my lord, I pray that my case should be considered. My lord, the submission that the accused 1 and accused 4 are hand in glove. My lord, I have at the very outset I had admitted that accused number 4, Injo Tiso, is my business partner, my lord. Therefore, when both of us are implicated in the case, therefore, my lord, it is not uncommon for us to join together as parties in a common bail application. So, my lord, that is my point. My lord, the other thing is that my learned senior had referred to Supreme Court judgment where he had submitted that in case of a heinous offense, anticipatory bail cannot be granted. And most respectfully, my lord, neither the IPC nor any other,
No, that's a
it
discretion.
does not define heinous offense. The
Also in the
only,
domain of
yes, my
discretion.
lord. The only definition that I could find, my lords, is in the Juvenile Justice Act, my lord. Section 233, my lord, that defines what heinous offense is. Heinous offense is defined, my lord, as a offense where the minimum punishment is 7 years. Respectfully, my lord, in
The
all the
JJ.
offenses here,
The JJ.
yes, my lord, just to refer to the definition, my lord, we have to have some reference point here, my lord. Heinous offense, my lord, minimum 7 years. Here, my lords, maximum 10 years, my lord, that where have been implicated. My lord, notwithstanding all of that, my lord, I humbly have appeared before this court. I undertake to appear and cooperate with the investigation. Kindly consider my health issues. And my lord, all the previous cases I have already submitted, my lord. I have either been discharged, acquitted, or there have been civil cases, my lord. That cannot be given criminal color, my lord, in respectful submission. And my lord, this is all out of business transaction, political rivalry, my lord. Therefore, all these factors may be considered pertaining to this case, my lord. My lord may kindly look into the facts of this case and consider my case favorable, my lord. I undertake to appear and subject myself to whatever restrictions my lordship imposes. That is my humble submission, my lord.
This has-
May I just a line, my lord, parting, my lord, my higher husband, my junior friend, my lord. Here, my lord, only one thing, my lord. Whatever is in black and white, that cannot be omitted, my lord. And I, my lord, we are just, my lord, students of law, my lord, lordship is sitting that side, my lord. The law laid down, Article 141 says, my lord, the law laid down by the Supreme Court, the ratio, my lord, the law laid down by the Apex Court shall be applicable to all courts throughout the territory of India. Here, my lord, the ratio of this authority, my lord, one line, my lord, the 2025 one, my lord, in occurring at para 9, my lord. Munnes, my lord. Munnes, this is very important, my lord. This is the ratio. And is the law laid down, my lord. Be that as it may, since the petitioner has suppressed material facts at regard to his involvement in criminal cases, he is not entitled to the discretionary relief of bail. Have I made my position? They're in bail, not PRS bail. And the disjunctive, my lord, full stop. The rest is immaterial. Meaning thereby, one who doesn't come with clean hands, that regarding, my lord, criminal antecedents. If he says that there is no criminal case and there are criminal cases, he doesn't get bail, my lord. Have I made my position? Embargo is there. Here it is PRS bail. And this authority would be applicable. Have I made my position clear, my lord? And in their again, I am repeating page 6 paragraph. Kindly see the line. Subsequently, they say, when we say that there are 11 cases pending, they say there are 4 out of the dragnet, my lord. 7 are remaining, but they are like, kindly, can they erase it, my lord? On this count itself, the application doesn't stand, with all respect and forbearance. Para 5, second line. The petitioners, this is the language, my lord, is a respectable citizen of society and not involved in any criminal case. Have I made my position clear, my lord? They cannot say it is clerical mistake, my lord. This is our case, my lord.
My lord, just a clarification in response. My lord, I am a public figure, my lord. There's so many cases that are being lodged against me. I was only aware of these 4 where I've been acquitted, my lord. Therefore, I did not deem it fit to state that these cases are pending against me. I've been acquitted, my lord. Once I'm acquitted, nothing remains, my lord. And so far, the rest of the cases have been.
Acquitted cases won't be pending anyway.
Yes, my lord.
My lord,
I'm so
So
obliged.
anyway, still require reserving, I think.
my lord, anytime.
You have
And my
also-
lord, the cases he has cited are on, my lord, cancellation of bail, my lord.
you-
That
you-
Gujarat and other one, my
Both
lord.
sides have given me, you know,
My lord,
sufficient
my lord.
homework.
My lord,
I
as
have
your
to
lordship may take.
Need some time to.
Yes, my lord. Yes, my lord.
I'm
Yes.
so obliged for a patient hearing, my
No,
lord.
no, okay. Your
Yes.
good name, please?
My A. Borua, my lord.
A. Borua, Learned Counsel, assisted by?
I'm not a senior counsel, my lord.
No, that's fine.
Doesn't-
Junior name should be given also.
Otoli Kits.
Learned Counsel, appearing for the, no, all our counsels, appearing for the petitioner. Addresses arguments at length, and also submits several case laws. Heard G. Chutia, learned additional PP, appearing for the state, along with the case diary. Learned Counsel B. Mahajan, N. Mahajan, appears for the informed, and also addresses arguments at length, along with submission of case laws. The order is reserved, full stop. The case diary may be kept.
My lord, my lord.
I think it should be ready on.
My lord, any day. My lord.
On reopening, Wednesday it should be.
My
ready.
lord, Highly obliged, my lord.
I'm so obliged, my lord.
Obliged, my lord.
You have done good homework.
Thank you so much, ma'am.
I
I'm
appreciate
obliged.
it.
I'm obliged.
Young counsel, you have done good homework. Keep it up.
My lord, in this case, this is a bail application in a case where the trial is going on. The victim has been examined, cross-examined, discharged, then we move an application for re-examination. The re-examination has also been done. If I take your lordship directly to the evidence of the victim, your lordship will find that that was a consensual relationship and now she is of 18 years of age. Even the mother.
Regards to item number 45, my lord.
You want some upgradations?
No, my lord, I've not application. Their case diary has been received. But we have taken steps, my lord, upon the informant that has not been received. So if my learned friend, TP can take instruction. Yes, and next week, my lord, date can be fixed, my lord.
Just 45. Can TCR received?
Case diary, my lord.
Case diary is received. So, however, the service report upon informant not yet received back. The prosecution shall take instructions regarding the same. You retain the CD, no?
My lord, CD.
Case diary be retained. List on
23rd, my lord. Yeah, since pending August, my lord.
23 or 24.
23rd, my lord.
23/10/2020. 24 and 23. No, item 45.
45, yes, yes. I'm obliged. Deputy.
23. Comment.
Lordship, this is second application and today he has completed 56 days. 60 days offense, Lordship.
Second application. Earlier was rejected.
Rejected, my lord. Serious cyber offense, my lord. Various, my lord. You rejected,
Detention
lordship.
period only, Lordship.
Now
Diary has
in
been
case-
received.
Yes, case diary, yes, my lord. Case diary, updated case diary available, my lord. Yes, he is,
These are all 60-day offenses.
60 days offense.
56 days today, Lordship.
Your lordship may fix it on 22.
Lordship, 21 day, 60 days will be completed.
61st day, we can fix it, yes.
That's-
His right will be finalized on the 61st day.
Lordship,
61st day will be which day, which date? Can we
Yes,
calculate?
Lordship, mandatory period will be over on 21.
On 21?
21, yes, that is why Lordship.
No, no,
Even
see,
Lordship, even
60 days
Lordship,
will be completed on 21st.
21st, Lordship.
Then we can actually,
That's-
as you know, madam, the right starts from the 61st day. You know, within 60 days, they can file the charge sheet. If not, then on 61st day. So if the 61st day is on holiday, then we have to
From
dispose of.
tomorrow, Lordship, even Lordship is allowing today, he cannot come out, Lordship, because that is why, Lordship, considering the length of detention, Lordship. And today they cannot.
on my lord,
it's within
22nd, my lord, 60 days. On 22nd, my lord, on the opening day, my lord, 22. That will be completed. On that day, my lord, 60 days will be completed on 22. On 23rd, my lord, that would be 61 days.
60 days will be completed on 21, Lordship.
No, he says it is on 22nd. Because, just don't worry about, don't bother about 60 days. Just see when 61st day will be completed.
Yes, 61st day will be on, my lord, 23rd of.
22, Lordship.
So on merits, there are a lot of, problems.
Yes,
Anyway,
On
that will be better.
21st.
Because the third.
Lordship, considering the detention period, Lordship.
Oh, let
has
them get a
undergone already,
full
Lordship.
chance, the investigating authority to submit their charge sheet. Otherwise, of course, you will get it as a matter of right.
Yes, my lord.
Correct?
60 days will be completed on 20.
One, Lordship,
One
21.
and my lord, 22 on 22 on the opening day, 61 days. The
For
day-
formalities has to be kept. Okay, in that case, I'll dispose it of.
Lordship.
Dispose it of. No purpose will be served. So, আমার আগৰ এইটো পেজ নম্বৰ 22 পেজ নম্বৰ 22 আছে। আপনি first, second, third. Okay. Very. This is the subsequent bail application, as an earlier bail application was rejected on 15/9/2025. Passed in BA 2909 of 25. Comma, a copy of which has been fairly annexed with the bail petition. Full stop. The said bail application was rejected after perusal of case diaries and noticing the incriminating materials therein. Full stop. The learned additional PT submits that the nature of the allegations is quite serious, involving cyber crimes. However, it is admitted that the applicable statutory period would be 60 days, and that the same would be over on 21st of October 2025. Full stop. The next 4 days are holidays in this court, including 21st of October 2025. The aforesaid facts and circumstances, I am of the considered view that considering the length of detention and the fact that the matter is on the eve of completion of the statutory period, and the next few days being holidays, the accused can be granted bail at this stage by accepting the subsequent prayer for bail. Accordingly, it's allowed to go on bail of rupees 40,000 with one stated of the like amount, the satisfaction of the concerned learned court, and subject to the conditions that he shall cooperate with remaining in this. CD was received, right?
CD received.
CD case diary was received. And it is revealed that investigation is not yet complete. He will cooperate with remaining investigation, not hamper or tamper with it, not commit any illegal activities or offense. Return CD, bail petition stands disposed of.
And the problem.
Yeah, please, your lordship.
My lord, 53, my lord, we have not gone through the case diary, my lord, after some time. no.
Arms act is there.
Yes, sir. Minutes, I have been shot back at above the torso minutes. I was in GMCH, now I've been discharged minutes. The FI is at page 17.
My lord, voluminous case diary, my lord, I have not gone through the case diary, my lord, I don't know about 53. Yeah, anticipatory bail, my lord. Mm.
Just a minute. Okay.
Should I continue?
This will take some time.
Yes, my lord. Please.
Let it,
Why upgraded then?
let it come up.
There was no justification for upgrading.
Let it come after some time minutes. I am not on interim minutes.
Anyway, many are not on interview.
Yes.
There's some special reason why it should be upgraded. Jumping the queue. Time being? এটা আছে time. আৰু কেইটা আছে time? Amicus is appointed?
Yes.
instruction.
My lord, service not completed, my lord. My lord, here, my lord, we take a instruction from the OC concerned, my lord. They have informed that, my lord, they received the same. But my lord, that is for the execution, the ASI to whom, my lord, that is, my lord, entrusted, my lord. He is in, my lord, another duty, my lord. So give us a time, my lord. Immediately after opening the court, we will, my lord, submit it, my lord.
And it's a CD was called for, this is.
So it is succeeded case,
My lord, succeeded case, my lord.
Can
Scan TCR, my lord, receipt, my lord.
already scan copy received.
Scan TCR receipt, only the part of the, my lord, service, my lord.
it is submitted by the learned prosecution that while scan TCR is available, but the jurisdictional police could not execute the process of service and seek some time for the thing,
Right.
some time for the same.
My lord.
List the matter on
My lord, on 22nd, my lord.
22nd.
Immediately, my lord. Because we have already communicated only that part, or 23rd, my lord.
List the matter on 23/10/2023.
23.
Item, my lord, item 46 also.
46,
Same case, out of same FIR.
Okay.
46 also, same.
Oblige.
Same, 46 also.
My pleasure, lordship.
You have a copy? You've received?
No, actually, my lord, I skipped this matter because my name came as Das, my lord. Actually, I write my full name, so I skipped it.
Okay.
It কি রকম পাঙ্গালা? এটা কি হলো?
436 days, your lordship, he is in custody. And out of 9, your lordship, 3 witnesses have.
Just reminder. Interim bail granted by the order 19/9, since extended till the next date of listing. Fix on
10, 11, 12, 25.
10/11.
Lordship, it's from Kasalo.
Yes.
Happy?
My lord, in this case, sketch copy is called for, but not come. And in the meantime, two witnesses has already been examined. So rational number 2 is not appeared. He refused, I come to London, he refused to accept the notice. So amicus curiae may be appointed and matter will be fixed on
You have to take instruction,
24.
right?
Everything, whether service is completed or not.
No, the service, I said, she is not received a notice. So but amicus curiae may be appointed, no?
Then maybe,
No, but he must be right, but officially. through
yes,
your
yes, we have
channel
to take
it will be
instruction,
better.
lordship.
You take an instruction.
But matter will be fixed on 24, my lord. The amicus curiae will be.
The learned counsel submits, Mr. Ahmed submits that as per his instruction, the service upon the informant was refused. Notice upon informant was refused. The prosecution shall take instruction.
Lordship.
Notice is awaited.
Scan, scan record is available, right? Scan
This year not
record,
available.
Scan copy is not also.
not yet received. That will also.
So
be
issue reminder for
necessary.
that.
Exactly.
Issue reminder for the scan copy of case diary and charge sheet.
Lordship.
That will do.
Earlier, my lord, it has been sent to the Kamrup.
Okay. List the matter on, when do you want it?
My lord, 25, my lord.
Will it come?
All the accused persons are released on bail. 2 persons, 2 witnesses have already been examined.
25 is very early. Lordship, 25 in a holiday also.
27, my lord, 27. I know.
It comes, there's no problem. Let's go.
May I please your lordship? Lordship, here in this matter, the trial court records have received, but the
Yeah.
service upon the
Yeah.
respondent is awaited.
Mhm.
And in the main case, deposition of the victim and her informant is already done.
Already
my
done.
lordship. So, my lordship, only instructions of my senior with regard to this service, can it be fixed on 24 with that regard? If that be so, then amicus can be appointed, it can be proceeded.
We have to take instruction because
You take-
Lordship, take
Learned-
instruction whether service is completed or not.
The prosecution shall take instruction regarding service upon or upon the informant. List the matter on
Any-
24th.
24, my lordship.
24 is, 25, Lordship.
25
25 is holiday.
Fourth Saturday.
27.
Twe-
During
Then in that case, 28, I'll be outstation
Lordship,
court
28,
27,
28.
20.
Obliged, my lordship.
Lordship, I'd like to mention that item number 29. In this
29?
case, yes, he is the student of IIT Guwahati, Lordship, and pursuing PhD. And he has been booked under immoral trafficking from a spa, Lordship. Main accused has been already released by the learned additional session just Kamrup Guwahati after perusal of CD, Lordship. And he will appear in examination
This,
very soon.
In this case, the charge sheet submitted in this case.
Charge sheet, but lordship in this case, main accused has been already released and he is a student, lordship. He was,
He's on interim bail.
yes, lordship.
Charge sheet is also submitted.
Yes, Lordship.
Make it absolute.
Yes, lordship.
তো আগৰ লিখাটোৰ পৰা লৈ ল'ব ঠিক আছে One, two, three. Four. The accused petitioner was granted interim bail on 10/9/2025. Stop. The learned additional PP DP Goswami submits that in the meantime, investigation is also completed. Charge sheet has been submitted.
Yes, Lordship.
Resulting in a charge sheet. Full stop. In view of the same, the interim bail granted the accused fight order dated 10/9/2025 is hereby made absolute, subject to the condition that he shall cooperate with the process of law. Bail petition stands dismissed.
Obliged.
32.
One lady was arrested on allegation that the lordship 1.943 kg of suspected to be ganja recovered from us. And lordship.
Just a minute, Learned Counsel. Regular, normal list of. Naha. CTT to Naha. Huh? Regular, say yes. Find it. Oh, Peter, this is actually regular list, but we'll, since it has come up, I'll take it. It's a intermediate quantity, right?
Yes. Lordship. Today is 58 days, lordship.
Okay. 8 days.
Yes, my lord, 1.941 kg of ganja recovered from the present petitioner, residence of the present petitioner. Initially, one accused person was arrested on being leaded by him from the residence of the present petitioner that 1.94 kg of ganja was recovered. Today is 58 days.
58 days.
50.
He has completed, no, this is, it was led by the another accused.
Yes, initially one accused, my lord, was arrested. Thereafter, on being leaded by him from the residence of the present petitioner, my lord, that 1.9.
The third, your good name, please?
SS Bora.
HS Bora, Learned Counsel. 483 bail application. Laluk PS case 165 or 25 members. Allegation is about recovery of one intermediate quantity within bracket 1.943 kg of within bracket close of suspected ganja from the premises of the present accused, on the police being led by a co-accused. He was arrested on 21/8/2025 and stated to have completed 58 days as on today. The case diary has been received. Learned prosecution submits that investigation lends support to the allegations. However, the same is not yet complete. In view of the same and also considering the applicable statutory period of 60 days and the fact that the next 4 days are not working days in this court, dash at that one. I am of the considered view that the accused should be granted bail at this stage, according 30,000 with one surety. Shall not hamper or tamper the evidence. He shall not misuse his liberty to commit any legal activities, including any activities prohibited by the NDPS Act. Right? return back case diary. It stands disposed of.
To the satisfaction of.
Yeah, concerned learned.
Right.
Which court? This?
Special Das, NDPS Lakhimpur.
Lakhimpur.
Obliged.
Not Lakhimpur. 37.
34 to 9.
37.
37.
Not received.
37, my lord, case diary not received. my lord. Huh? Oh, dear. Yes, ma'am. Okay.
Lordship, the scan copy is received, Lordship, but we have not gone through the scan copy.
So you
Lordship.
not gone-
So we have fixed on short date, Lordship, we'll go to the scan copy and.
We have to go into 37, then you'll have to go see. it.
NDPS case.
Anyway,
27.
those scan PCR is received. But prosecution seek some time to go through the same. This is the matter. When should I fix?
2017, 2017. Lordship.
27?
Obliged.
Sir, do you, the learned counsel, the petition? 27 then. Yes, there is not received.
Here in this case, Lordship,
Interim order is there.
main allegation is that, Lordship, he was loading some betel nuts in his truck. And that betel nut owner is already granted bail by your Lordship.
No,
And,
he is also granted.
He is on interim, Lordship, and as per my instructions, charge sheet is submitted. So probably they can apprise this court whether charge sheet is submitted or not.
In that case, we can make it absolute.
Yes, because he already appeared. There was some confusion, so your Lordship wanted to clarify that aspect.
No
That
instruction.
instruction we don't have, my lord.
Don't have.
Let me know immediately after reopening, my lord. Then we fix.
The petitioner is on interim protection by the order dated 17/3/2025. The case diary is not received, right?
Case diary not
It
received,
is
my lord.
not received. Should reminder, list on.
Lordship, I think 23rd or 24th.
24th, my lord. 23rd or 24th, interim, he is in interim, my
24.
20.
Obliged.
Production.
Production list item number 1.
My pleasure, Lordship. Lordship, in this case, Lordship, and second time, Lordship, 86 days is as on today, Lordship. And today's item list, item number, Lordship, 4 and 59, Lordship, already been grant bail, Lordship.
Okay.
Out of same affair, same forwarding.
Okay, I'll dispose it of.
Lordship. And
Without problem.
today's item number 4 and
Yes.
59, same,
I've done proofreading also
Lordship.
of that order.
Deeply obliged, Lordship. Obliged.
Put it on, এটা without problem. Chamber. Diary, updated diary received? Not received.
My lord, 47 not received, my lord.
Not received. Case diary is not received. The updated case diary is not received. Issue reminder, list on. It's AB, no interim, it seems. Wherever there is interim, you can fix a longer date.
My lord.
28,
28, my lord.
28,
28, my lord.
28.
Wait, please, Lordship.
Diary, I think.
My lord, diary not received, my lord, in this matter.
Lordship, my humble prayer is that there are 3 female petitioners, Lordship. Out of 18 petitioners, there are 3 Omen lordship. And there is no interim lordship. I am praying for interim only for those, POXO. POXO here is their lordship, 18 petitioners are there, but that's not true. There are 5 petitioners are arrested, and these 3 lady petitioners are their sister, mother. Like this lordship.
POXO is there, then my lord service, no,
Yeah, have you issued notice?
No, lordship, other day,
Yes, issue the notice because many
council,
cases I have seen, it gets delayed due to the notice. Kindly take the steps.
lordship, other day, learned council appeared for respondent, informant lordship.
Many allegations it seems. Anyway, it will be better to see the case diary. The case diary is not yet received. Issue reminder. Steps may be taken upon the respond number 2.
Lordship already.
my lord in 50, my lord, in the cause list, my lord, from the informant sides, my lord.
Informant appear on
it
the
is
last.
stated. So,
Lordship.
no, as it is stated in the cause list, my lord.
It appears that, sorry, it is submitted by the prosecution that learned counsel has already entered appearance on behalf of the informant. Informant, however, is not implemented, but they have appeared.
Yes, my lord, because my lord, in the cause list, it is shown, my lord.
Issue reminder for the case.
Lordship, the
No.
3 women.
No, it will be little different. I don't know why, because there are some, I saw some AK-47 house with, entering the house with. AK.
Those
It
are
might-
their
it Might be a complex issue.
5
complex-
accused persons are arrested, and these lady accused persons are their mother and
They
sister
cannot
lordship.
be implicated for POXO, per se.
I am
So it is
saying,
gender neutral, but let us see the diary, one more date.
My lord.
When do you,
date,
when can you?
My lord, it is from my lord Dhubri, my lord, Sapor.
February,
So,
27,
yes, my lord.
27.
27.
Obliged, Lordship.
27, 27.
40.
Please, lordship.
It is
482 bail application in. Lordship.
Diary not received.
Yes, lordship, my father is awaiting for operation, serious operation, open bypass surgery, lordship, very soon. So kindly be considering the length of detention as well as the medical, on medical ground, lordship.
You are paying for informant?
Informant.
Because I. what is-
Imposing any terms and
I have no
conditions,
idea what
lordship, I may be allowed.
Not gone into it. Diary is not received, right?
Diary not received, my lord, pray for a date, my lord, immediately, my lord, after reopening, my lord,
Just immediately after reopening. Okay.
immediately, my lord.
Is the Dispur PS.
Dispur, my lord.
No, that will be additional as Waterford, learned counsel appearing for the informant side. Is there issue, press reminder for the case diary? It's list on
My lord, 23rd or 24th?
23rd.
23rd.
2310.
2310.
82.
Lordship, timing lordship.
My lord, 52 also, my lord, CD not received, my lord.
It's not received, so
My
let's
lord.
fix it another date.
Yes, my lord.
Yes, case diary is not received.
My lord, here, my lord, is a case of TCR, my lord.
Oh.
TCR, my lord,
hold on.
TCR, my lord, but my
Hold on.
lord, TCR, we are not able to go through, my lord. So kindly fix, my lord, date, my lord, immediately, my lord, after reopening, my lord. My lord, it is also a, my lord, NDPS matter, my lord, commercial quantity, my lord.
The learned prosecution seek some time to go through the scanned case record receipt and stuff. Prayer is allowed. So we'll, on 23rd?
My lord, can it be 24th, my lord?
24th.
24th, my lord.
24th.
24th.
Is it okay for?
Yes,
You
yes,
tell me if there's any difficulty.
Okay, let's say.
24th. Just brief your senior academy.
62.
May I please, Your Lordship? CD is not here, my lord. As on today, 88 days behind the bar, my lord. 88 days, my lord. FIR is on page 8,
309 is what? That is
90 days, my lord.
90 days. No, that's true. Not received. He will complete the statutory period. Yes, ma'am.
My lord, my lord. Otherwise, armed secret is there, my lord.
But the allegations are serious.
My lord.
Dacoity with arms and all. Anyway,
My lord.
483 bail application heard. Mr. Rahman,
M. Rahman.
bail application. Sila Pothar PSP. 138 of Philip. Accused was arrested on 21/7. Stated to have completed 88 days in custody. His diary is not yet received. Instead, next few days, next 4 days being not working days in this court, comma. The accused shall complete the statutory period, applicable statutory period of 90 days in the midst of this 4 non-working days. Full stop. Therefore, on the length of detention, the aforesaid factor, comma, I deem it fit to grant bail, though the nature of the allegations are on the serious side. In this, allowed to go on 50,000 with one surety. With the satisfaction of the concerned learned court.
CGM Dhemaji, my lord. CGM Dhemaji.
Dhemaji. And subject to the conditions, number 1, he shall not hamper or tamper with evidence. He shall not intimidate or harm the informant and his family. He shall not misuse his liberty to commit any illegal activities or offences. Will petition stands allowed.
My lord, my one submission may be recorded, that my lord, regarding the seriousness of the offense,
Yes,
my lord, I,
uh,
my lord.
The learned additional PP,
Without-
A. Boyce submits that considering the seriousness of the allegations, the bail may be rejected at this case.
My-
Online.
No.
39. May I please your lordship?
Oxo? My, yeah.
Lordship, in the petitioner has is a lady before Lordship, and she is a teacher by profession, Lordship, assistant teacher. An allegation against her that she did not report a incident that had happened in
That's
the
a
school.
stringent provision, right?
Yes, Lordship.
Not reporting is also an offense.
Yes, it is a,
They preferred a writ petition before this court, which was dismissed, leading to a SLP before the Honorable Supreme Court. Investigation has progressed.
Yes, Lord.
Investigation is stated to have reasonably progressed. In the given situation, it's not necessary to cancel the interim bail. And accordingly, the same is made absolute, subject to the condition that he shall not hamper or tamper with evidence. Return CD, bail petition stands post.
Obliged, Lordship.
Yes.
Please, Lordship, in item number 40, Lordship, inadvertently I will be out of station, Lordship. Kindly you make it on 22nd or 24th
Okay, last item.
of life.
No, I did not.
Item number 40. my lord,
40.
40.
Earlier.
40.
Already your lordship has fixed.
Already
item-
been fixed, Lordship.
It is-
23rd.
Your lordship has already fixed
Oh,
on
because
25.
difficulty on.
Yes,
Yes, right.
No problem, I'll accommodate.
22nd or 24th, Lordship.
Okay, no issue. 24th. 24th, sir, 24th, 24th,
Of life.
24th.
Much obliged.
No problem.
Item number 34, my lord, case diary received.
He has crossed the mandatory period of detention.
Charge sheet not yet submitted. Already
20 B2B.
mandatory period of for filing charge sheet is already over.
483 bail application. So, Kuala Kusi PS case number 72 of me. Accused was arrested on 13/8/2025. Diary has been received.
Diary received.
The Kothapur learned additional PP fairly submitted, though diary has been received, but the investigation is not completed. And in the meantime, the applicable statutory period of 60 days in the instant case is also overcome. In view of the same, the accused is hereby allowed to go on bail of rupees 25,000 with 102. Instruction of the concerned court.
Judicial Minister First Class Hajo, Lordship.
Hajo,
Lordship.
all Kusi also.
Lordship.
That's across the river.
Yes. Forwarding report if you go Judicial Minister.
Yeah, I had also worked
Yes, yes.
in that district. So certificate concerned learned court, JMFC Hajo, and subject to the condition that shall not hamper or tamper with evidence, he shall not commit any illegal activities or offences. Return CD, bail petition stands disposed.
I'm obliged.
Yeah, in this case also, my lord, I am 56 days today, my lord. And my lord, allegation is serious, my lord. They have affair, love affair, my lord. That of my lord.
Three matters.